আমার পেছনে দেখতে পাচ্ছিস ওখানে আমার খাতা স্তূপ, বইয়ের স্তূপ।
আরে খাতা বইয়ের স্তূপ দেখতে ভালো লাগে, আমার দেখুন এই যে ব্যাগের স্তূপ।
আচ্ছা আচ্ছা, তোর কি ডেস্কটপ থেকে করছিস না ল্যাপটপ থেকে করছিস?
হ্যাঁ বলো বলো। আমার ল্যাপটপ খারাপ হয়ে গেছে, নিজের মতো স্ক্রল করে যাচ্ছে, আমি কিচ্ছু করতে পারছি না ল্যাপটপ থেকে।
এবার ঠিক আছে ঠিক আছে।
যে আমার চুলটা দেখেছিস কেমন হয়েছে?
হ্যাঁ ভালো কেটেছিস তো। কে কাটলো? নিজেই
পার্লারে কেটেছি এবার আমি।
আচ্ছা আমার তো বউ মেয়ে বউ সবাই মিলে চালাচ্ছে এক্সপেরিমেন্ট, মোটামুটি ঠিকই আছে না?
আমি তো বাবার চুল তো আমি
এই না 10:42 হয়ে গেছে, যখন খুশি কেয়ারফুল হতে হবে, আর কথা বলা যাবে না।
10:45
এটা কিন্তু পুরো এই শ্রেয়া, এটা কিন্তু পুরো রেকর্ডিং হচ্ছে না তো?
না
ইউটিউবে যাচ্ছে কি?
না অরিত্র এখন
অরিত্র তুই কোথায় গেলি? এই অরিত্র কতবার নেই।
10:45 থেকে কিন্তু আমাদের উচিত পার্টিসিপেন্টস অ্যালাউ করা।
হ্যাঁ
অরিত্র যদি গ্রিন সিগন্যাল না দেয় আমি এটা করতে পারবো না।
অরিত্র
আরে চিৎকার করছেন কারণ আমাদের কানে লাগছে। অরিত্র, আমি অনুপাদিকে বলবো স্ট্রিমারটা নিয়ে পুরো মাথার মাঝখান থেকে চালিয়ে দিতে।
আরে আমি করেছি এবার অ্যাক্সিডেন্টালি স্ট্রিমারের ইয়েটা, অরিত্র হ্যান্ডওভার হয়ে যাক তারপরে এটা করবেন।
আমি তো পারবো না, শ্রেয়াকে করতে হবে।
শ্রেয়া করবে, আপনি কেন টেনশন নিচ্ছেন? শ্রেয়া করবে।
আচ্ছা আমি যদি এরকম করে বলি,
মেলটা আমি আগে খুলবো, আগে আমি ফোল্ডার বানাবো, পেপার 5 পেপার 6 পেপার 7 পেপার 8 আর জেনারেল ফোল্ডার বানিয়ে
ফাইনালের জন্য বলছিস?
ফাইনাল আজকেও ফোল্ডার বানিয়ে আলাদা আলাদা করে দেবো, তারপর আপনারা খুলবেন।
ঠিক আছে
ঠিক আছে
ওকে।
আজকে পরীক্ষা নিয়ে স্টুডেন্টরা পাগল হয়ে করে দিচ্ছে পুরো, ওরা বুঝতেই পারছে না।
বাংলা ডিপার্টমেন্ট কিন্তু সবাইকে হয়তো দুটো থেকে জয়েন করবে।
আবার কি শিখবেন
বাংলা ডিপার্টমেন্ট?
স্যার
আরেকটা
দুটোই স্যার অরিত্র।
আমি বেরিয়ে গিয়ে স্যার আমি আমার পার্সোনাল থেকে।
শ্রেয়া
বলো।
শ্রেয়া বাংলা ডিপার্টমেন্ট কি বলেছে জানিস?
বলেছে
তোমাদের অনলাইন করতেই হবে, তারপরে জমা করো। এটা হয় নাকি?
কি
বলেছে তোমাদের অনলাইন সাবমিট করতেই হবে, তারপরে কলেজে এসে জমা করো অফলাইন।
না স্যার এটা থেকে
অরিত্র আমরা কখন অ্যালাউ করব?
স্যার আমরা আর কটা বাজে, আর 5 মিনিট পর অ্যালাউ করতে পারি স্যার। আমি লাইভ স্ট্রিমটা স্টার্ট করে দিয়েছি, আমি লাইভ স্ট্রিমের লিংকটা দিয়ে দিচ্ছি এখানে স্যার।
আচ্ছা আচ্ছা, দীপঙ্করকে ফোন করবি কেউ?
তাহলে আমরা এন্ট্রি অ্যালাউ করব অরিত্র।
আর 5 মিনিট ওয়েট করে দিন, মোটামুটি 10:45 বাজে।
কারণ কি 10:30 কান্নাবিরান ম্যাম কিন্তু জয়েন করতে চাইছিলেন।
10:30টার সময়?
হ্যাঁ, আমি ডিনাই করতে হয়েছে আমাকে।
আমি তো মানে একটু আগে হয়ে যাচ্ছে স্পিকারদের জন্য।
আমি স্যারকে দিয়ে মেসেজ করিয়েছি যে টেকনিক্যাল টেস্ট চলছে।
কে জয়েন করতে চাইছে?
এখন আপাতত কেউ করছে না, স্টুডেন্টরা চাইছে 2-3 জন।
এখন ভেরিফিকেশন সম্ভব নয়, আমাদের ওয়েবিনার চলছে।
এটা কি
ডিবি ফোন করছেন না? ওটা বলে বাঁশরি দি নাকি?
না, we are allowing participants অরিত্র।
না আমি তো অ্যালাউ করিনি।
তাহলে এটা কি?
এটা কে ঢুকলো? ভূগোল বাঁশরি ঢুকেছে।
স্যার আমি জাস্ট একটু কনফার্ম করে নিতে চাই স্যার। স্যার ইন্ট্রোডাকশনের পর স্যার আমাকে দেওয়া হবে, আমি আপনাকে দেবো তো স্যার?
না, ইন্ট্রোডাকশনের পর তো মানে শঙ্খমালা বলবে তো, শঙ্খমালার পর তুই ঢুকছিস, ঢুকে তারপর তুই আমাকে দিয়ে দিচ্ছিস।
Yes sir, মানে I would now request Dr. Shambhalendra Majumdar to introduce the respected speakers.
ও আচ্ছা, তুই তাই করবি, শঙ্খমালার পরেই তাহলে তুই ঢুক। শঙ্খমালার পরেই
we are allowing participants। আমি কিন্তু অ্যালাউ করছি না।
তাহলে কি করে ঢুকছে এরা?
আরেকজন শিবনাথ শাস্ত্রী অনলাইন আছে, এটা কে?
না আমি দুটো অ্যাকাউন্ট থেকে আছি, কিন্তু আমি তো অ্যালাউ করছি না এখন।
তাহলে ঢুকছে কি করে? চৈতালি কর্মকার ঢুকে এলো, এটা কি করে হচ্ছে?
এখন 47 বেজেই গেছে, যাই হোক। স্যার তাহলে সেটাই আমরা করতে পারি স্যার। তাহলে আমি ইনস্ট্রাকশনসটা দিয়ে স্যার আপনাকে পাস অন করে দেবো স্যার।
ওকে, ইয়েস ডান
দিদি
ডান।
ফোন ধরছেন না।
স্যার আপনি একটু শর্টে ইন্ট্রোডিউস করে দেবেন, আমি ওই স্লাইডটা দেখিয়ে দেবো ওই দুজন স্পিকারের, যেটা সমদাদি বানিয়েছে। তারপর স্যার ওভার টু
আমার তো বেশ বড় আছে, বড় ইন্ট্রোডাকশন আছে, মানে ওই ইন্ট্রোডাকশন খুব বড়
না। অরিত্র,
হ্যাঁ
এসএম যখন ইন্ট্রোডাকশনটা দেবে তুই স্লাইডটা জাস্ট একটা স্ক্রিনে দিয়ে রাখিস বরং, তাহলেই হবে।
হ্যাঁ হ্যাঁ, মানে ওটা মানে ইনস্ট্রাকশন টু পার্টিসিপেন্ট এর পরে হবে তো সেটা, মানে
হ্যাঁ নিশ্চয়ই।
হ্যাঁ।
হ্যাঁ, মানে ইনস্ট্রাকশন টু পার্টিসিপেন্ট আমি বলে দিলাম, তারপর স্যারকে দিয়ে দিলাম, স্যার যখন বলতে থাকবে তখন ওই স্লাইডটা আমি দেখিয়ে দেবো আর কি।
এক্স্যাক্টলি
হ্যাঁ, তারপর স্যার উইল পাস অন টু দ্য স্পিকার।
ওকে, ইয়া দ্যাট ইজ আউট। দীপঙ্কর ফোন ধরছে না?
ইয়েস স্যার।
দীপঙ্কর ফোন ধরছে না?
দিদি ফোন ধরছেন না।
কি বলবো বলো?
আমি কি স্লাইডটা একবার দেখিয়ে নেবো? আগেরটার মতনই আছে, জাস্ট একটু চেঞ্জ করেছে।
দেখিয়ে নে এসএম। আর শ্রেয়া তো দেখেনি বোধহয়।
ওকে,
শ্রেয়া দেখেছিস?
না।
ফার্স্ট পেজটা এরকম একটু আমি জাস্ট এটা দিয়ে দিয়েছি, আর তারপর ইনস্ট্রাকশন গুলো আছে পরপর, যেগুলো আমি জাস্ট বলতে থাকবো। আমি লিঙ্কটা আপডেট করে দিয়েছি, আজকের লিঙ্কটা। আর স্পিকারের ইয়েতে স্যার যখন বলা শুরু করবে তখন আমি স্পিকারের স্লাইডটা অন করে দেবো। স্যার আপনি দেখতে পাচ্ছেন?
এসএম দেখে নিয়েছেন?
আনমিউট করুন।
স্যার ফোন করছেন হয়তো, আমি জানি
না।
আচ্ছা, এটা মোটামুটি সমতাদি যেটা বানিয়েছিল সেটাই আমি জাস্ট কপি পেস্ট করে দিয়েছি, মানে
আনমিউট করুন এসএম আনমিউট করুন।
চৈতালি তুই প্লিজ একটু ডিবি কে ফোন করে বল না জয়েন করছে না কেন।
আচ্ছা
একটু তুই বল, এক্ষুনি বল, দেরি হয়ে যাবে আমাদের। আমি এদের স্পিকারদের বলবো তো অ্যালাউ করবে, জয়েন করতে বলবো তো।
হ্যাঁ, রুচিরা গোস্বামী ম্যাম ইজ জয়েন্ড আস।
জয়েন, ফাইন।
গুড মর্নিং ম্যাম।
গুড মর্নিং।
Good morning, Vijay.
Ma'am, you need to unmute yourself.
Good morning, everybody. Good morning, Shamalendra.
Good morning. Very good morning.
Acha, I just have a quick question. এইটা কি bilingual রাখবো না only in English?
Only in English.
Only English.
Oritra,
হ্যাঁ শ্রেয়াদি কিছু বলছিলেন?
রেকর্ডিংটা শুরু করে দিয়েছি।
হ্যাঁ, রেকর্ডিং শুরু করে দিয়েছে, লাইভ স্ট্রিমও চলছে, লাইভ স্ট্রিমিং এ দাও।
ঠিক আছে।
I just
Please join. চৈতালি পেলি?
না, ফোনে পাচ্ছি না, আমি মেসেজ করলাম, দেখছি আরেকবার।
তুই একে বুমকাকে বল।
আচ্ছা, আমি দেখছি।
শঙ্খমালা জয়েন করেছে?
হ্যাঁ, জয়েন করেছে।
Thank you. Good morning, Kalpan.
ম্যাম।
গুড মর্নিং ম্যাম।
Ma'am, you need to unmute yourself.
Good morning, Kalpana.
You have to unmute yourself.
Ma'am, please. Yes, ma'am.
Good morning, everybody.
Participants, do not write greetings in the chat box. It's a request to you all. Please use the chat box only for your questions.
You should assume your greetings.
I think everyone is here, so we can just start at 11 then.
Exactly, Akhil.
Yes, exactly at 11 we can start.
Just 7 minutes left. So I'll call. So, Kalpana, the job pressure is really getting over me. I mean, I'm just bogged down with CRG work so much. Every day I have to receive a call from CRG. Someone has some problem, and this is becoming a really bothersome affair.
Yeah.
And that too, we are always on tenterhooks because of Ranavidya. I mean, he gets so angry with us
Yeah.
if any mistake is committed. So we are terrified, both me, myself, and Samantha. Really.
But
Tough.
also, CRG is on an overdrive. You know, they're
Yeah.
doing so many things, and everything
Yeah.
is like a mega event.
Exactly.
And, you know, it's not easy to do that. I mean, I think one thing that the lockdown should actually teach us to do is to
Go slow.
step down, to slow down, you know, rather than to get into a total frenzy at not. You know, the point is, it can't be that because of the lockdown, you end up doing 5 times the amount of work you ordinarily do. And our ordinary work routines are not light, you know.
Exactly.
So you end up doing 5 times more, and it's really very taxing.
Exactly.
You know, I mean, it's not easy to be on the computer screen, and it takes
Always,
away
yeah.
time, you know,
Absolutely.
just calmness of mind, everything.
Absolutely. Absolutely.
So, you know, I
Yes,
mean,
Kira.
of course, these online events are a boon in the sense that they are, you know, they are cost effective. Certainly, you can get
Yeah.
anybody from any corner of the world at no cost. And also time, you know, in terms of travel time, and, you know, they
Yeah.
save energy.
Yeah.
But then what's the use of having those benefits if at the end you end up with deep stress,
Exactly.
you
And
know?
I'm just
So,
scared about Ranavidya's health.
yeah.
Ranavidya is taking so much of,
Yeah. No, I mean, you know, ordinarily in physical meetings itself, he was on overdrive, you know. So, I mean,
Yeah.
somewhere somebody has to put through a medical advisory to him that he can only do two,
Exactly.
two
Who
online
will,
meetings a week.
who will bell the cat?
Well,
Ranavidya, you know Ranavidya, so.
yeah. So I think, you know, that, which is why I'm actually refusing. I just am point blank refusing to go on to online meetings. I do one once in 2 weeks. I don't even have one every week. If I do one on one week, then I refuse to do one the following week. Because I would much rather spend time just reading and writing and, you know,
Exactly.
doing things. And also, I'm physically at my office, so I don't actually have the luxury of staying home.
Yeah.
So for me to do online meetings also is like huge, because then I have a 30-kilometer and 60-kilometer commute
Up
to my
down.
office and back. And then it becomes just all too much. But even by itself, I think, you know, this online hysteria has to actually go down.
Yeah. It will have a telling effect on our head, doesn't it?
Very much. Yeah, very much.
So it's 57, so you get ready.
Yes, sir.
Okay, I'm just going to mute my mic while you
Yeah.
finish your stuff. So.
Same here.
Sir, so I think Shankamalati will start.
Yeah. What is your opinion? What do you want to say, Aritwa?
Yes, sir, I'm just saying that Shankamalati will start at 11. She will be the one starting
I will
next.
start, then Shankamala will continue. Okay?
Okay, great.
Let me start.
Great. So we are almost on time.
There's 3 minutes left to 11.
Yes. Just to inform everybody that it's being live streamed. The link is given in the chat box if anyone wants to share it through YouTube, then they can share that. And the meet link has been sent to all the participants, so I'm sure more people will soon join us. All the technical tests are done, I think. Sriyadi can inform us if anything is left. And we're good to go.
Aritra, the moment Samatadi begins, then you start the Gmeet recording.
All right. Yes, anyway, the live stream has been started, so one recording is already
Okay.
recorded once.
Samantha, get ready.
I'll start then. It's
Yes,
almost 11.
please.
So, very good morning to our eminent speakers, our colleagues, and our participants. I'm Shamata Bishwas from Women's Studies Department, Shivnath Shastri College. I welcome you all to our one-day webinar on inequality, equity, and the law, the myth of gender justice in India. Today, our principal ma'am is not being able to join us because of some official reason. So I request our faculty member from political science, Shankhamala, to give the inaugural speech on behalf of our principal ma'am. So I'll hand over this to Shankhamala now. Thank you.
Very good morning to all. Am I audible?
Yes, you're audible.
Thank you, Shamutadi. So I'm going to read out the message from our principal ma'am, Dr. Runa Bishesh, and she's also the chief patron of this webinar. Unfortunately, she has not been able to present today. I welcome every one of you to this one-day webinar, Inequality, Equity, and the Law, Myth of Gender Justice in India, organized by the Departments of History, Political Science, and Women's Studies in collaboration with IQAC, Shivnath Shastri College. I'm really glad that today we have with us two very distinguished speakers, Dr. Kalpana Kannaviran and Dr. Ruchira Goswami, who will speak on the legal and social aspects of gender justice in our country and why the term gender justice has been characterized by a mythical phantasm. Gender, as we know, refers to the social attributes and opportunities associated between male and female. These attributes, opportunities, and relationships are socially constructed and are learned through socialization process. They are context and time specific and changeable. However, in most societies, there are differences and inequalities between women and men in responsibilities assigned, activities undertaken, access to and control over resources, as well as decision-making opportunities. Discriminations against women persist in many areas, directly or indirectly, through laws and policies, gender-based stereotypes, social norms, and practices. Besides, gender identity is not binary. Non-binary people are also included in gender. United Nations statistics show that only 67 countries out of the UN members legally ban discrimination based on sexual orientation in employment. Only 20 countries banned discrimination based on gender identity, and only 143 out of 195 countries guaranteed equality between women and men in their constitutions. Nevertheless, the study of gender is crucial because it explores how women's subordination and transgender people's alienation is socially constructed. The subordination and alienation can be ended as it is not biologically preordained. Very recently, we have seen that the Afghan government has accepted a proposal to put mothers' names on their children's birth certificates, in an extraordinary win for women's rights activists in this deeply conservative country. So we should not lose hope, but we will never cease to study the socio-legal structure that leads to the mythification of gender justice in our country. Thank you. I'll now request Dr. Shamulindu Mojumdar, HOD, Department of Political Science, to introduce.
Hello. Hello. Before I begin, I ask Aritro to describe everything about this particular webinar. He's a technical support. So he will explain everything from the Department of History.
Thank you, sir. I'll draw the attention of all the participants to my screen. I'm presenting my screen. We'll just go through some basic instructions and rules that will help us conduct this webinar effectively and enrich all the participants concerned. So the first thing is my screen visible? Can anyone confirm?
Yes, it is visible.
Thank you. So the first thing that I wish to mention once more is that we are live on Google Meet. The link has already been sent to all the participants. Live stream is taking place through this channel, and the live stream video link has been pasted in the chat box. Instructions for participants: please keep your microphone and video turned off at all times. This is a non-negotiable rule. If anyone turns off their video or their microphone again and again, we will be forced to ask them to move to the live stream. They will not be allowed to continue in the Google Meet. If there are any queries, please send them to the following emails, which are also mentioned in the brochure, and we will try to solve them as soon as possible if they're technical in nature. If there are queries or questions or suggestions for the distinguished speakers, in that case, we will note them down and we will ask those questions on your behalf, on the participants' behalf, to the distinguished speakers, but only during the question answer session. Nobody will unmute themselves and interject or interrupt the speakers. If we find anyone doing that, we will be forced to remove that participant. Instructions regarding certificate: at the very end of the webinar, after the vote of thanks, we will share a link for the feedback and attendance form. And once you fill up the form, the certificate will be sent to your email address. So we will not be able to send the link, the feedback link, through email to every participant. You would have to be present during the last part of the webinar to be able to receive the link in the chat box. We will also put the link in the live stream chat box. On that note, I would call upon Dr. Shamulindu Majumdar, Associate Professor in Political Science, Shivnath Shastri College, to introduce our speakers and take the session forward. So,
A very, very good morning to our esteemed speakers and participants and our colleagues. You know, it is my proud privilege to have this opportunity to introduce to erudite scholars in the in this field. Apart from their scholasticism, they are known for their activism in ensuring gender justice. The issue of gender justice has occupied a central position in most socio-political discourses. The first speaker, as we all know, is a very well-known personality, Dr. Kalpana Kannabiran. She's an Indian sociologist and a lawyer. She is the current director of Council for Social Development, Hyderabad. She is also the co-founder of Ashwita. It is a resource center for women, a women's rights group. She is a daughter of the notable human rights activist KG Kandaviran. Actually, we all know about Mr. Kandaviran. He was the most illustrious human rights activist in those years. And she has obtained a PhD degree from JNU. In 2003, Kandaviran was awarded VKRV Rao Prize for Social Science Research in the field of social aspect of law by the ICSSR, beg your pardon. She was also a member of the expert group on the Equal Opportunity Commission, Government of India from 2007 to 2008. She was also the General Secretary of Indian Association for Women's Studies from 1998 to 2000. Her topic, citizenship, gender, and constitution and commons. I welcome Dr. Kannabiran.
Yeah.
Thank you for her much awaited speech.
Thank you. How long do I have, Shamlenduda?
It's around 45 minutes.
I won't take that long, but yeah. Good morning, friends, and I would like to begin with offering thanks to the organizers, especially to my good friend, Professor Shyamalendra Majumdar, for this invitation. What I will try to do today, we all know the nuts and bolts of gender justice, so to speak. But what I plan to do today is to try and recap some of the older debates around equal citizenship for women, changes in laws, but also at the very basic level, what is it that we understood in the past as dignity and equality for women, and how has that understanding shifted or changed, and what do we understand today as central concerns around the question of equality and dignity based on gender. So you will notice that already when we are talking about past debates on gender justice, we are talking about equality and dignity for women. And then when we move further to the present, then there is a marked shift in the focus to looking at equality and dignity on the basis of gender. And this shift is extremely significant, and it will be one of the aspects of what I will be focusing on. Very broadly, what have been the major concerns when we talk about equality and dignity for women? What have been the major concerns? In fact, it suddenly came to my mind that a friend sent me a message yesterday that the person who is likely to replace Justice Ruth Bader Ginsburg is somebody who believes that women should be subservient to their husbands. So we move back to the debates in the colonial period, but also in the up until the 1970s in India, where the full recognition of women as equal partners, as equal citizens, as people with an equal stake in the constitution was simply not recognized. And it has taken the deaths and the gruesome deaths of several hundreds of women in order for us to actually be able to push through at least a legal recognition that equality is a right that is fused with women's rights to citizenship under the Constitution. And you will find that the struggles that have been waged across this period have been many. You have struggles around the question of family violence, particularly wife battering and domestic violence. And this is a reality that women have faced across class, caste, and community. And the struggle to actually recognize that domestic violence is a crime, that husbands, spouses, live-in partners don't actually have the right to assault or kill the wife, is something that was not automatically understood. It took a huge mobilization on the part of women's groups across the country in order to bring that recognition. There were different spaces in which this mobilization took place. It took place in small groups in urban centers. It took place within community spaces. One of the largest, spaces of mobilization against domestic violence have, for instance, been by Muslim women in very, very different, spaces where these issues were discussed among women of the community, and resolutions sought to actually protect Muslim women from domestic violence, of which the whole phenomenon of unilateral divorce was part. And the phenomenon of unilateral divorce was not something that was restricted to Muslim women. Desertion and dispossession of women from the matrimonial home is something that you see again across different social groups and classes. So domestic violence then, and I'm actually just telescoping a very large debate into just a couple of paragraphs. So it will be kind of choppy and not very smooth, but I think that it's important to get a sense of the terrain that we are speaking of. The second major issue on which you saw mobilization and a claim to justice under the Constitution, and a claim to criminal law that actually recognized the fact of women's suffering, was around the issue of rape. And around the issue of rape as well, the first cases that drew national attention were cases of custodial violence. So 1978 and 79, you had the Ramiza B case in Hyderabad and the Mathura case in Maharashtra. The Mathura case, and both Mathura was an Adivasi girl, 15 or 16 years of age, who was assaulted in a police station. Ramiza B, and Ramiza B was about 17 years of age when she was assaulted, and her husband was killed in police custody in Hyderabad in 1978. And so the focus on the question of rape began around custodial rape. Of course, there was an earlier history to it in the early 20th century, where you had marital rape being at the center of the concern of women reformers particularly, and the entire movement around raising the age of consent. But within, if you take the period from about 1965, 68 onwards, in the 70s, the major issues that come up that literally burst on the national scene are the questions of domestic violence and the question of custodial rape. And I would like to, in order to historicize our discussion of rape, because somehow I think we have reached a point where we, kind of trace the campaign for reform in laws of sexual assault back to the December 2012 incident in Delhi. It's actually much older than that. And in order to just give you a sense of that history, I would like to dwell briefly on the case of Ramiza B in Hyderabad, which will also give you a sense that Mathura, in fact, doesn't give you. It also gives you a sense of the deep intersectionalities in the discussion on rape. Which is a question that continues. It comes up again and again and again. It came up for us with Khairlanji. The debates came up again with reference to the Jyoti Singh rape in 2012, with the amendments to the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act, and rape of Dalit women as atrocities. So the question of the intersectional experience of sexual assault has been something that has been very much part of the historical experience of campaigning for reform in rape laws, whether it was articulated as intersectionality or not. Is another matter. But the fact is, as experience, it was, something which you actually couldn't make sense of if you didn't see the intersections, understand them, and try to grapple with them theoretically. So with Ramiza B, very briefly, what was it that happened? Ramiza, 17 years old, was married to Ahmed Hussain, they were coming back from a late night show, and the police then picked both of them up in Hyderabad city, took them to a police station, and the husband was sent back, and Ramiza was raped in custody by 3 policemen. She returned home and told her husband that, and Ahmed Hussain went back to the police station to ask the police why they had done that, and they beat him to death. So what we had in Hyderabad then, and this was the end of March 30th, 31st, 1978, we had a woman who had been raped by 3 policemen in custody, and her husband who had been killed. And literally, the city went up in flames. There were protests. Everything came to a standstill. There was protests. There were arsons, and there was a completely unified platform that was put out by all political parties, right from the Majlis Ittihad al-Muslimin to the CPI to the CPM. Everybody was, was very clear that this is not something that one could take lying down. That was also the very beginning of the feminist movement and the beginning of, women's groups starting to think about autonomous feminism, as it was called then. And owing to the pressure of citizens, we in fact had the state government constituting a commission of inquiry, headed a one-man commission of inquiry by a sitting judge of the AP High Court, Justice Muqtadar. And the commission was given staff from the High Court, and it conducted the inquiry as it would conduct a trial. So there were witnesses, there was cross-examination of witnesses, there was forensic examination of forensic evidence, there was examination of the accused, cross-examination of the accused, and the commission then gave a very detailed report which stated that according to the findings presented before it, the policemen were in fact guilty of custodial rape and murder. This was the report given by the commission, by a judge who constituted the commission of inquiry. You also then had the report being tabled before the assembly. You had a very lengthy debate in the assembly around this issue. And then, of course, is when the rollback starts. So in terms of what was achieved in pushing the question of the women's right to personal autonomy, to bodily integrity, to dignity, the right against assault, the right to life under the Constitution with dignity, what was achieved in the public articulation in this case is quite unparalleled. Also setting up a commission which is not a people's tribunal or a people's commission. It was a regular, commission of inquiry constituted by the government. And that entire process itself, I think, shifted the articulation of women's rights to a very different place. From something that is unspeakable, unspoken of, not public, something where the law is derailed, you suddenly had, a very different sensibility being rolled in as a result of this case. Then, of course, the derailment of law starts after that, where the policemen then go to the Supreme Court and say that where the High Court judge has pronounced against them, it is unlikely that a trial court judge will go against the decision of the High Court judge. So the trial courts in AP will be biased against them in the criminal trial. So they wanted the criminal trial to be shifted to another state. So the criminal trial, the Supreme Court granted their plea. Please note the places where the derailment takes place. The Supreme Court granted their plea. The case was transferred to Karnataka. It was tried in Karnataka. And the trial court in Karnataka acquitted all the policemen. And then there was an appeal in the Bangalore High Court. The Bangalore High Court confirmed the acquittal. So, when we talk about justice for women, one of the things that I'm constantly also trying to think through is, what are the sites of justice? Nobody knows what happened to Ramizabi after the Karnataka verdict in 1981 or the High Court verdict in 1984. But in terms of in terms of what she went through, in terms of the interiorities of a victim of gruesome sexual assault, we know next to nothing. But what we do know something about is what it takes to actually shift the parameters of the public conscience. Because we hear this term again and again in the judiciary, we hear the term again and again with our lawyers, particularly who are arguing, to support, that section of lawyers who are arguing to support anti-minority and anti-Dalit violence. we constantly hear the terms we need to satisfy the collective conscience. And I think that we need to remember some of the cases that women brought to court and to judicial processes, where the question of public conscience, the question of a collective responsibility to build a public conscience on women's personhood and rights actually succeeded in shifting the terms of the discourse. The actual victory in court then is one part of it. The larger part of shifting the parameters for an understanding of justice is part of that entire process of deliberation that carries on through. I mean, she was a very ordinary working class Muslim woman who had been caught by the police. And the manner in which the entire city came to an absolute standstill over that case and the level of protests that one saw gives us a very different sense of what the limits of the possible are if we in fact build public campaigns around women's rights. And in a sense, I feel that maybe that is the direction in which we should go on feminist mobilizing, and feminist resistance, even to this in the present. So rape and domestic violence. With domestic violence, around that time, I don't know if this was the case in other cities in the country, but certainly in AP, the term that we constantly used was Nirbhaya deaths, because suddenly we found that all women, all middle-class women particularly, were only using kerosene stoves of the brand that was called Nirbhaya. They were only using Nirbhaya stoves for cooking in the late 70s and early 80s. And all of a sudden, these Nirbhaya stoves, just had technical flaws and kept bursting and killing women with 90% and 95% and 100% burns. And the question was, what happened? Why were women being assaulted and killed in this kind of gruesome manner? So we were not anymore talking about battery. We were not anymore talking about women being beaten by their husbands or being assaulted, or we were talking about women who were killed in the most gruesome manner in their matrimonial homes. And this was again, and this struggle was one that saw protests across the country, mainly in cities. And oddly enough, you had very, very similar forms of violence, used against wives in matrimonial homes across the country. And again, like with the question of rape, this was the trigger for the feminist mobilizing, in which there were several mothers of women who had been killed. Satyarani Chadda was one such, completely an unparalleled figure in the fight against domestic violence. And she passed away, I think, recently, a couple of years ago or so. This was again, a phenomenon. This experience of domestic violence was again something that brought up a large campaign that resulted in far-reaching changes in the criminal law to incorporate violence against wives and the murder of wives as separate sections in the criminal law. And when we speak about gender equality and dignity and constitutionalism where it concerns women. The one thing that is extremely clear through the history that we have gone through is that none of these questions are resolved on their own through a dispassionate interpretation of the Constitution in courts. These are changes to the interpretation, not changes to the Constitution, because the Constitution says it all. It is changes to the interpretation of Constitution and criminal laws that were brought about by movements and mass resistance by women across the country. You have, for instance, in Nagpur, Seema Sakhare, who has become a legend because of her indefatigable campaigns to bring husbands who had murdered their wives to book. It was countless. Every conference of the Indian Association of Women's Studies that she came for, she would just reel out these figures for Maharashtra alone. And several of the cases she had personally intervened in. So there were women like this who were leading these struggles. And there were women like this who actually pushed for a recognition of women's right to equality and dignity under the Constitution. You also had questions of the recognition of equal rights vis-a-vis workspaces, the right to promotion, the right to service for as long as men were in service, the case of the air hostesses, as they were called then in Air India, for instance, which senior advocate Indira Jaisingh fought, but also, importantly, the case on sexual harassment of women at the workplace, that there is an infringement of the recognition that there is an infringement of the right to life, equality, and dignity if women remain vulnerable to sexual assault and harassment in the workplace, is again something that that comes to the fore as a result of massive struggles. The first known case that we have in this regard is, of course, the case of the IAS officer Rupam Deol Bajaj, who was groped by no less than the person the police call their absolute hero, KPS Gill. And what was important was that Gill was sentenced to a term in prison for sexual harassment. But at that time, it was still called outraging the modesty of a woman. It wasn't yet sexual harassment. But from an IAS officer, it then moves to Bhavri Devi. And the massive struggle that Bhavri Devi put up in the case of her own experience of assault and her own, devising her own methods within movements to bring a very different sensibility of what it means to counter, to counter humiliation that fuses discrimination based on gender with caste-based humiliation of Dalit women. So with the case of Bhavri Devi, with the case of Ramisa, you have the issue of the experience of a Muslim woman, a poor Muslim woman, at the hands of the police and the callousness of governments and courts in that respect. When we move 2 decades later to Bhavri Devi, we witness the articulation of sexual violence, sexual assault, and its intersection with caste orders that makes Dalit women vulnerable on multiple intersecting grounds. And how do we then articulate that vulnerability? How do we build movements that address that that intersectional vulnerability? And how do we take that articulation forward so that that experience of an intersecting vulnerability, in fact, informs our understanding of sexual assault and sexual harassment. So with Bhavri Devi, again, at the level of the trial court, you have no justice. The perpetrators are acquitted. But when the case is brought up as a case of sexual harassment against women at workplaces, we have the rolling out of the Vishakha guidelines and then a legislation that recognizes sexual harassment at the workplace. And of course, in that intervening period, we have several ways in which the standard of protection against sexual harassment in the workplace for women is entrenched both in public and in private institutions. It falls far short. It's not enough, but it still can't be seen as something that is insignificant because it shifts the public perception of what is normal behavior outside of that realm of the normal. Of course, when you look at the question of sexual harassment, then you move from there. So till Bhavri Devi and the Vishakha guidelines, we are still talking about due process. We are still talking about complaints mechanisms. We are still talking about redressal forums that must follow a certain procedure. And that again shifts considerably when we come to the entire movements, and I'm saying movements, not a single movement, movements around Me Too, not just in India, but elsewhere as well, but also in India, in very, very different spaces, by very, very different actors within the space of movements, within the space of employment, within the space of collegial interactions. What is acceptable and dignified behavior between men and women that does not infringe on women's right to bodily integrity, to personal autonomy, and to dignity. And of course, with the Me Too movement, there has been a wide-ranging debate. It has, it has people for it, people against it. It has articulations that are fairly nuanced and complex. I don't have the time at the moment to go into those details, but except to say that with the movement, with the Me Too movement, what we see is a renewed debate on the place of law as distinct from the place of justice, where it concerns women's right to equality and dignity. And I think that distinction between law and justice is something that we need to be very mindful of. And part of the effort of women's groups has also been to bring the law and justice as close to each other as possible. With the 2003 conference in Durban against all forms of racial discrimination, we witnessed a very large mobilization. Perhaps, although it had its beginnings with the Beijing conference in 1995, with the Durban conference, it completely grows into a very different formation where you have Dalit women across the country, articulating their experience of caste as, caste as, and I'm not saying casteism, I'm saying their experience of caste as racism, that has very, very specific gender implications and gender articulations. And this is an articulation that continues to the present day and presents very, very sharp critiques of positions of women's rights and equality that do not, or are that are unmindful of the question of intersections and intersectionality. So the point basically that I've been trying to make so far is that, and also with the articulation by women from Dalit feminist groups on the question of caste as racism and its gendered implications, you have the amendment in the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act. If you look at the amended definition of atrocity, you will find that several of the clauses that define atrocity are clauses that speak to the specific experience of Dalit and Adivasi women. So the point that I have been also trying to make is that you can only see changes in the law, you can only see very, very measurable legal reform where that legal reform is very closely tied to popular or to mass mobilization by oppressed groups. And that mass mobilization by oppressed groups, one of the major things that it tries to do is to address the question of social humiliation and systemic humiliation. And I think that that is a crux, whether we are talking about domestic violence or sexual assault or sexual harassment or any of the other forms of sexual denigration that takes place. We are essentially talking about women's right against public or socially sanctioned humiliation. From there, the first point that I raised was the kind of a shift that we witness from looking at questions of women's equality to looking at gender equality. And what we find then, again, in 2009, is the decision of the Delhi High Court in Naz Foundation, which brings up the question of LGBTQI rights in a way that was never witnessed earlier in relation to Section 377 of the Indian Penal Code. And this is a large segment of gender-based rights against derogation, against humiliation, and against criminalization that had not entered into the account of gender equality prior to that. But again, when Naz Foundation comes up, if you look at if you look beyond the judgment of the Delhi High Court, you will find that again it is the stunning mobilization by LGBTQI groups on the question of dignity and autonomy under the Constitution that pushes the court to decide on the constitutionality of Section 377. So again, it isn't the court that of its own accord takes note of this and rolls out a decision, but the court relies very much on the public articulation of gay rights, of LGBTQI rights by communities themselves, and the recounting of experiences of derogation by communities, and takes that on board in order to examine whether or not the interpretation of the Constitution should shift, because the Constitution itself draws no boundaries and no borders. It says equality and non-discrimination based on sex. The question is, how will courts interpret sex? So will courts use the male heterosexual norm, or will courts step aside from that and say, let's open this category of sex out and say, how will we begin to decide on whether something is a gender-based or a sex-based discrimination or not? And of course, then from NAS, you have several developments. The absolutely, what is a blot is, of course, the Suresh Kumar Kaushal decision. But then again, we have the full bench decision in Navdeep Johar in 2018, which is again not a single person, it's not a single petitioner, it is the entire cluster of groups that had been campaigning across the country in every state. And so what we see in the Navdeep Johar judgment is a validation of LGBTQI rights that draws on the collective experience of queer communities across the country. And interestingly for me, when the Navdeep Johar judgment comes up, we find that the Supreme Court, in fact, doesn't have the words to express solidarity. And I have written about this at length elsewhere. So it takes recourse to poetry to explain something that legal language simply cannot express. So you will find right from Shakespeare to Oscar Wilde to Ambedkari Shahirs, you'll find a range of poets walking through Bikram Seth. You'll find a range of poets walking through Navdeep Johar. But that also means that the kind of emotion that LGBTQ groups across the country stirred in the minds of the judges is something that was quite unprecedented. And so we are today at a point where we are not simply talking about women's rights to equality and equity. The old problems, of course, remain. You have women still killed within marriage. You have women who have opted for choice marriages being killed by their natal families, or their partners being killed by their natal families. We had a case in Hyderabad a few days ago, another case a couple of years ago. We have cases in Tamil Nadu, and we have an NGO in Tamil Nadu that just puts together cases where the untold caste violence is perpetrated on people marrying out of choice. So we have these problems that continue to persist. But, like my father was fond of saying, there is no conclusion because the struggle is its own reward. So you can't say that the business of women's equality has been completed, the task has been completed, and it's now done and dusted. But rather, it is an incessant, ongoing struggle that must move to newer and newer and newer locales. Because with the spread of right-wing violence, with the spread of hate politics, with the spread of the muzzling of dissent, what you have is gender-based violence taking very, very different forms, hate speech taking very, very different forms. And so our own strategies at Feminist Mobilizing must keep constantly shifting and revitalizing itself in order to be able to confront all of these movements that just seem to proliferate in front of us. So I will actually end on that note, that when we talk about rights to dignity and life, we are talking about the Constitution as a commons. It is not the property of a court. It is not the property of a profession. It belongs to us all. It belongs to people of all genders, irrespective of gender. It speaks to each of us in very specific ways, depending on our own specific locations. And the only way in which we can actually make the Constitution speak most effectively for all of us is that if we are able to build solidarities across struggles, if we are able to recognize that there is never ever any conclusion to dissent, there is never ever any conclusion to a struggle, and that we must acknowledge that really the struggle is its own reward. And as long as we recognize that, I think we will just keep going on with the business of struggling, with the task of struggling, and with the commitment to struggle and to resist. Thank you.
Thank you, Kalpana, for the excellent speech. Well, Dr. Kalpana Gandaviran has covered a long area, starting from domestic violence, then rape, marital rape, and the reform laws associated with that, and then with particular attention on sexual assault, and her emphasis on certain aspect of intersectionality in sexual assault, and she has referred to an incident where a woman was raped in the police station, and when her husband went to complain against that, he himself was beaten to death. So then he talked about the Nirbhaya case and the way women are burnt alive as a result of domestic violence. And it's not merely domestic assault, or I should say domestic violence. It's something more than that. The killing was gruesome in character. And she also mentioned the name of some great warriors who fought gallantly for ensuring this kind of gender justice. And then she turned to sexual harassment in workplace, and she referred to the famous case of Rupan Dev Bajaj, where KPS Gill was really forced to undergo punishment. And then she referred to the Vishaka guidelines, the Me Too movement, and how Me Too movement has really raised the feminist movement, or feminist, what should I say, approach. It has given it a new paradigm altogether. And actually, she had referred to the Durban conference, where Dalit women projected successfully caste as racism, and a new articulation mode about gender justice was raised there. Then she referred to legal reforms and mass mobilization of the oppressed group. She referred to the Delhi High Court verdict on LGBT 2009. So everything, all that she had said, she had really covered a huge area regarding gender justice, and it's highly inspiring speech in the sense we can really hope that someday or other mass mobilization and sensitization of the general public about this would certainly ensure the dawn of a new morning altogether. So with this, thank you, Kalpana. Now I turn to Dr. Ruchira Goswami. Ruchira Goswami is associated with National University of Juridical Science in 2000. She offers courses in sociology, human rights law, and gender and law. As a British Chevening scholar, she has a postgraduate degree in human rights from London School of Economics. She has been a visiting lecturer in international development studies at the International Summer School, University of Oslo. She's also a guest faculty in MPhil courses in Women's Studies at Jadavpur University, Calcutta, and postgraduate courses in Sociology of Crime and Deviance in Calcutta University. She regularly conducts human rights training programs for youth, women, and personnel in governmental and voluntary associations. She is one of the founders She's one of the founders of Gender and Law Association, one of the trustees of Anjali, a voluntary organization based in Calcutta that works in the area of human rights and mental health. She's a member of Nari Nirjatan Protirod Moncho, an activist feminist organization in Calcutta, and Moitri, a women's rights network, and also associated with various human rights organizations at the local and national level. Our topic today is women's movement and legal reforms, mapping the dynamics. Welcome, Ruchira. Welcome, Dr. Ruchira Goswami. We are awaiting for your deliberation.
Thank you very much. Good afternoon, everybody. And it is an honor and a privilege to be a part of this national seminar on gender justice. And thank you for a scintillating speech, Dr. Kalpana Kannabiran. I mean, a lot of things that I thought that I'd be talking about, she's already set the tone so beautifully that mine will sort of echo a lot of things that she's already said. Thank you very much. And I'll just briefly talk about very similar grounds that Kalpana has already spoken about. But I'll try and also look at the dynamics between the Indian women's movements and legal reforms. So sort of not looking at only the wins, but also to look at what quote unquote the losses were and how do we, as Kalpana ended, how do we re-strategize to continuously talk about more and more rights for all social groups. So just to start, you know, when the pandemic started, a lot of people were saying that the pandemic is a great leveler, that, you know, it really doesn't distinguish between the rich and the poor, the male and the female, and everybody can be affected by it. Nothing can be far from the truth, because what the pandemic showed us was how starkly unequal the society is, and how different social groups are affected very, very differently by this pandemic. And of course, I'm not getting into the migrant workers crisis or the farmers crisis, any of that. But clearly, one of the groups which has been differentially affected by the pandemic has been women. And continuously since March, when the lockdown was announced till now, within a month of the lockdown, we saw that there was a doubling of cases of domestic violence and the reports that came to the National Commission of Women. We saw a rise in child sexual abuse, in child marriage, in trafficking and child labor. So nothing stopped. All of this sort of went up. A lot of human rights violations have been going up. I'm not even getting into different kinds of legislations that were passed during this period. So the pandemic really shows us the rising inequalities in our society, gender being one of them. The second point that I wanted to talk about is already something that was spoken by the previous speaker and during the introduction, that when we talk about gender, we are not only talking about women, we are talking about a whole range of people within this gender galaxy, and not just women alone. Gender does not mean talking about women, it also means talking about the power differentials that exist between men and women and between other social hierarchies and other social groups, including that of the LGBTIQ. The fourth point is that women are not a monolith, and Professor Kannabiran talked about this at great length, that while intersectionality is a term that we see being used in many discussions today, the experience of intersectionality was already felt by the social movements and the women's rights movement, though not using the term intersectionality particularly, through its experience had already talked about that. So the understanding of intersectionality actually existed within the Indian women's movements and other social movements prior to 1989, when we see the term being coined and being put to use by Kimberly Crenshaw. So let's look at that. While we are saying that women are not a monolith, and we are looking at the various distinctions between and among women, and between women as a social category and other groups, while also needs to understand, and again, something that I will not discuss, what it is to be a woman. You know, if you're not looking at the biological argument of womanhood, but social experience of womanhood, how do we experience womanhood? So that is also a huge discussion in itself, into which I am not really going. So if we go back a little in history and we look at how laws relating to women have changed over time, and we see a lot of these current legislations that we have their roots in the colonial past. So many current legislations in India, it started in the colonial period, and then over a course of time, it got amended. And one of the significant ones are around issues of dowry, which started with a colonial legislation called Leti Deti Act. And then, of course, the issue of child marriage, which started in the 1880s, right, with the case of Rukmabai and with the case of Pulmoni, and in the 1880s. And then we see a very, very new legislation coming in 2006, which is Prohibition of Child Marriage Act. And also later, very, very recently, there is this deliberation of raising the age of marriage for girls from 18 to 21 years. So if you're looking at this last lap, I don't know if it's the last lap, but if you're looking at this raising of age of marriage from 18 to 21, the beginning was during the colonial period. So there are many acts which transcend from the colonial to the post-colonial. And there are many such legislations that emerged during independence, and it shifted over the course of time. And a whole set of legislation, something again that Professor Kannabiran had discussed, were articulated during the 1980s when the autonomous women's movements began. And then that also saw a lot of amendments. So to quickly look at these range of legislations around women's rights, and say from the middle of 2000s on LGBTIQA rights, especially rights which were articulated by the queer movements in India. So let's quickly look at what these shifts were. So from colonial to post-colonial, and then looking at laws in the colonial period that were sexist, which is actually prohibiting women from certain sectors. So they were laws that excluded women, say, from the right to property, or from the right to vote, or from the right to be in certain kinds of employment. So as a feminist legal scholar, Carol Smart, argues that laws actually shifted, and this is globally, including that in India, that shift from being completely sexist or exclusionary about women to laws being male. So they are including women, but the experience of law is very androcentric. When you say experience of law, something that feminist scholars have discussed is, you know, when you go to a court, when you meet lawyers, the substantive provision of the law, that resonates with male experience of the law. And that is what we mean by the law as being male. And the third is that apparently the law might look egalitarian, but the law is gendered, which is how law itself creates a gendered perspective. and there is a very long discussion as to how law creates its own gendering of women, the good mother, bad mother syndrome, the good woman, bad woman syndrome in law. And this is very clearly also seen when you're looking at sexual assault laws in India or the rape laws in India, as we say. And this is very interesting. The good woman, bad woman, or the good rape victim and the bad rape victim, something that feminists have continuously talked about in law, which is what we call the genderedness of the law. And this is clearly exemplified if you're looking at the Nirbhaya case. Quote unquote, Nirbhaya itself is a very complicated term to use, I think, personally. But if you're looking at the Jyoti Singh rape case in 2012, and this moment of widespread disruption, anger, collective conscience being shaken, and this is one moment that we think of. Kalpana had already talked about Mathura and Rami Sabi, so I'm not getting there. So there have been these moments of collective conscience being shaken, and there is this huge dissent on the Nirbhaya rape case in 2012. Very interestingly, at the same point of time in Calcutta, as some of you might remember, was this rape of Suzette Jordan, who was raped in a moving car when she came out of a dance from a nightclub and got into a car and was raped by 4 men. Very interestingly, that did not make it so much. There was a lot of writing, but then there was this victim blaming that Suzette had gotten. And it seemed that, while when we are talking of Jyoti Singh, she seemed to be the ideal rape victim, Suzette wasn't, because she was the single mother, a divorcee who was drunk, who was in a nightclub, who got into a car with men as if she called for her own sexual assault. On the other hand, Jyoti Singh wasn't that at all. She was with a male friend. She was a student. She was middle class. She was coming home from work, etc., etc. So, when we look at the public outcry, there is a background to this public outcry and why some cases make it and some others don't. In a similar time frame, there was also this case of a Dalit girl who was raped, cut up, and thrown in a nearby Nala. She lived in a shanty. She was raped outside her home. And there wasn't any discussion around that at all. So it also is an interesting question to find out which are these cases on which there is a public outcry and which cases do not really have such a public outcry. We need to understand that. And that is also how cases then, depending on the public outcry, is what we see in a court of law. Because in recent times, we are also seeing that the way courts act is also responding to what the public wants. And I will talk about this later, perhaps. So this is what I mean by the genderedness of the law, that the law creates its own ways of the ideal womanhood or the ideal personhood. Also, similarly, in the Indian context, there is this shifting that has been traced from colonial to post-colonial times. And we see, and it's a very similar kind of an argument that we see in the works of Brenda Kosman and Ratna Kapoor, where they argue that law has moved from a very patriarchal protectionist framework in India. And this patriarchal protectionist framework meant that women cannot be in certain kinds of jobs. Night work is banned for women. Women can't work in mines. Employment restrictions for women. And that kind of a framework, which is protectionist attitude, to a kind of a corrective attitude, which is where there was protection or patriarchal assumptions of the law had made corrections in the sense that, say, women were not entitled to matrimonial property, or women were not entitled to natal family property, especially if you were a married woman, you would not get your father's property, and you would not get agricultural property. And and these positions were corrected in the law, and gradually in contemporary times, married women are equally entitled under the Hindu property inheritance and succession laws to get their agricultural property of their parents as well. So, you have corrected our past inequalities. And thereafter, the final position that we have arrived at is that of egalitarianism. And we are looking at the Constitution, which clearly, through its fundamental rights principles, talks about equality of all kinds of social groups, including that of women, right? And non-discrimination before the law. Interestingly, just for a moment, let's look at these non-discrimination provisions in the law. And there are also these what we call special provisions in the Constitution. And in law, we call it formal equality in the law and substantive equality in the law. Formal equality is formal equality and non-discrimination provisions, but we also realize that formal equality will not work in a social structure which has traditional inequalities. So the law also guarantees substantive equality, in the sense when you're looking at existing social inequalities and making social legal provisions for women or for minorities, etc., etc. And this is what we call substantive provisions in the law, or what we call the move from de jure equality to de facto equality. Kalpana Kannabiran's own work is very interesting, and may I just stop here for a moment also to talk of this, is that, in India, what Kalpana herself argues in one of her papers is that substantive equality might also backfire for women at times, in the sense that we think that it is egalitarian, that's going to give women more equality, but it can also ghettoize women. So in the sense that when you have these substantive provisions in the law or special provisions in the law that says that that creates special provisions for women in work, what it has done, it can also ghettoize women in certain kinds of sectors and certain kinds of work, which is re-establishing gender norms over and over again. Or it can also create conditions when you can use substantive provisions in the law to say that, sorry, we cannot allow women to do this. So women will not be fighter pilots, right? Or women cannot work at night, or women cannot work in underground mines, right? And so instead of opening up more employment opportunities for women, it can restrict opportunities. So we also need to understand substantive equality not only as something that expands rights, but can also restrict rights for women. Okay, so let us also look at these things in the law. Okay, so the next point that I want to talk about, and which is that when we are looking at laws, we are looking at two major things in law. One is called civil laws, and the other is called criminal laws, right? Criminal laws are laws, criminal laws around women are the laws that identify certain offenses, and therefore, it gives out certain punishments. On the other hand, the civil law framework in India are the laws that control marriage, divorce, inheritance, succession / property rights, adoption, and custody for women. So civil laws in India, very interestingly, also have a third dimension, as most of you might know, that civil laws in India have to be mediated through religion, right? In the sense that our family laws are through Hindu or Muslim or Parsi.
You have to repeat. You got muted. You got muted.
I'm sorry. Okay. Just give me. Sorry. So, just to repeat that family laws in India are mediated through religion in the sense that marriage, divorce, custody, maintenance, adoption, all of this is mediated through religion in the sense what kind of religions do you have? Hindu, Islam, Christian, Parsi, etc. So we need to recognize that we do not have secular family laws except for a couple of provisions, say the Special Marriage Act in India, or you have the Indian Succession Act. All our laws relating to marriage, divorce, custody, etc., is mediated through religion. And that is interesting because that is linked to the question of triple talaq, in which I'll come later. Okay, now let's look at a couple of criminal law. We'll talk about triple talaq under civil law later. So interestingly, if you're looking at the whole host of criminal legislations, and if you're looking at, say, sexual harassment at workplace or Criminal Law Amendment Act, the Criminal Law Amendment Act is a new amendment legislation which came in 2013, which is bringing in a whole host of changes under the sexual assault law in India. As we were talking about, when we are looking at the rape laws in India, from the 80s, there were a lot of shift, and the last set of shifts came in 2013. And under this, you had several kinds of offenses against women which were not recognized earlier, comes under the purview of this law. For example, like acid attack or stalking or voyeurism, all of this becomes a part of this Criminal Law Amendment Act. Also, interestingly, for a very, very long time, the women's movements in India talked about rape beyond peno-vaginal offense. And there were many these back and forth discussions that came through Law Commission. I'm not getting into that whole terrain of what these dynamics and negotiations were. But finally, in 2013, we get a law which recognizes sexual assault beyond peno-vaginal offense and looks at a whole range of sexual assaults, right? Very interestingly, so there were a lot of gains. So one major demand of the women's movements in India has been recognizing marital rape as an offense from the 80s. Interestingly, in 2013, when we arrive at this new law, we still don't see the criminalization of marital rape. Clearly, the patriarchal understanding of family remains intact. That is one level that the women's movement could not cross in spite of repeated demands, right? So the legislation that came through does not acknowledge marital rape as an offense in spite of this Justice Verma committee report, which is this commission, that the committee that was instituted after the December 2012 rape case of Jyoti Singh, and it was done in record time. And there were many other recommendations that the Verma committee also made. The second demand that came from the women's movement that was echoed in the Verma committee was that that got reflected through the Armed Force Special Powers Act that gave impunity to to the army and to the personnel, to men in uniform, that they will not be tried by the law of the land, that sexual assault laws will not be applicable to men in uniform. And the women's movement and the human rights group had continuously said that the Armed Force Special Powers Act cannot give an impunity like this. So these men who commit rapes have to be tried by the law of the land. The Verma Committee upholds this demand and recommendation made by human rights and women's rights group. Interestingly, when finally we see the new law coming in, again we see that is excluded. So the not only patriarchy, but also the might of the state, the retention of the Armed Force Special Powers Act, and the retention of the impunity, even in cases of sexual assault by men in uniform, remains intact. So that is the second gain that we hoped that we will get, and we did not see that. The third, which is that women's groups, women's rights groups, the autonomous women's groups and the human rights groups kept on insisting that for all these cases of sexual assault against women, it is not death penalty that these groups are wanting. Even after Jyoti Singh, women's rights groups were not saying that hang the rapist or castrate the rapist and that's the solution. Clearly, there was evidence after evidence showing that death penalty is not a deterrence for any kind of crimes, including sexual crimes. Again, that does not come through. Death penalty is retained. There is what we call a playing to the gallery of sorts. We live in very, very violent times, and death penalty was retained. Death penalty was actually extended very strongly for child sexual offenses against children, sexual offenses against children, under what we call the POCSO Act, which came in 2012. Again, I would say a kind of I would say a failure of the women's movement to push that agenda through. So this becomes a very interesting question as to why are certain demands acknowledged? And then why are certain demands not acknowledged? Why do they fall between the cracks? Which voices are silenced and which voices are heard? Why was death penalty retained? Why was impunity of the armed personnel retained? Why was marital rape not criminalized? Because the women's rights group have been crying themselves hoarse over this since the 1980s. These are questions that we need to deliberate upon. So if we are looking at legal changes from the 1980s, which is when the autonomous women's movement came through, into now, we will perhaps not see a very neat progression from retrogressive laws to progressive laws. We see a continuous pendulum-like thing. We have progressive judgments, we have retrogressive judgments. And this had happened throughout the 80s and the 90s on rape laws. It has happened from 2005 to 2020 on domestic violence laws. And I'll talk about this. And this has become very, very evident on the point that Professor Kannabiran ended. If you are looking at the queer movement's demand for equality from the NAS Foundation to Navtej Johar, which is what something that Professor Kandabiran has already talked about. It's a pendulum. You have NAS Foundation, which decriminalizes consensual same-sex relationship. We have the Suresh Kumar Kaushal judgment, which completely says, no, this is against Indian culture, goes back and criminalizes, till we came to Navtej Johar, when again we are saying no, criminalization of same-sex consensual relationships in private is absolutely okay. So why is this happening? is this dependent on who the judges are? Is this dependent on what is the social and political atmosphere around? What is this dependent by, right? So these are interesting questions on which voices are heard and which voices get subdued. And is this dependent on, as I said, what the bench is, what, who the judges are, is what we are saying. So let's come back very quickly to one more significant debate, which was there through the rape law and through the sexual harassment at workplace, which is a new legislation that came from, as we say, the Bhavri Devi rape case, the Vishaka judgment, the Vishaka guidelines and the Vishaka judgment, and then the sexual harassment at workplace laws, which came in 2012. What was this debate that was common to the sexual harassment at workplace law and to the rape law? This was the debate on gender neutrality, which is, if we understand rape not only as peno-vaginal offense, then why cannot it be made gender neutral? This debate came in and around the 1990s to 2000. What was this debate? In the sense that, we, in and around late 90s, early 2000, we seeing the coming in and the discussion and an interrelationship in India that is developing between the women's rights groups on one hand and the queer groups on the other, right? They are different legal journeys, they are different struggles, but somewhere they did meet in India on certain issues. And one of the issues on which it met, there were a lot of differences as well, but one of the issues on which it met, and there were a lot of deliberations, is whether, if we have a sexual assault law, should it be made gender neutral? What about same-sex sexual assault? What about sexual assault and exploitation and discrimination against trans persons? So that pressure group starts articulating itself in India from the 1990s with the queer rights movement, right? And so one of the greatest debates was that if rape is not gender neutral, does it mean that, one, can men be raped by women? Can men be raped by other men? Can trans people be raped or sexually assaulted? And all these positions, if you're following the sexual assault debate, you will see all these positions are coming in. What a lot of women's rights groups and queer groups recommended to the Verma Committee in 2012 and early 2013 was that let the rape law not be made completely gender neutral, but gender specific when it comes to the victim or the survivor. That be made gender neutral, and the gender specific would be the perpetrator. What does this mean? Simply it means that the man is the perpetrator. So sexual assaults are committed by men. Men are perpetrators, and women and men and trans people can be victims, right? Instead of completely making it gender neutral. Because it was said, if you make it completely gender neutral in India, it will throw up a Pandora's box. So the moment a woman is going to say that, charges somebody with sexual assault, there'll be a counterclaim by that man saying that, no, she sexually assaulted me. So and it is not a viable thing in India. It is not to say that men cannot be sexually assaulted, but there are very few instances, and we have nothing on record that shows men are sexually assaulted by women, because we do not live in a power equation like that. So clearly men can be raped, but in certain kinds of context of incarceration or these kinds of spaces, right? So that was one debate that came through, that was whether sexual assault laws should be made partially gender neutral. And a lot of women's groups agreed to it, and most queer groups did. Again, when we see the sexual assault law coming in 2013, the Criminal Law Amendment Act, we see we are back to square one. All this discussion is not reflected in the law of gender neutrality of the victim and gender specificity of the perpetrator is not reflected in the law at all. So this is an interesting point. Why did it happen? I, for myself, don't have clear answers, but that is something for us to deliberate. That is one I already talked about, the death penalty thing. When we come to the sexual harassment at workplace, a similar question also came. Should sexual harassment at workplace laws be made gender neutral? Who are we to say that men cannot be sexually harassed by women? Because if sexual harassment is a question of power, and it is not a question of lust, it is a question of power equation in a workplace, why can't we assume that women can also harass men? So there was this huge discussion. And then again, when we see the law, it is very strange. It says that it is a woman who is a victim of sexual harassment at workplace, and it is a person who is a perpetrator. And this is complex position. What do you mean by person? It can mean men, women, trans persons, anything. So that is another very strange position that we have taken in the law. Also, when legal shifts happen and we think that laws are progressive and that is going to benefit women, the way social reactions happen is very complicated, in the sense that we have a couple of progressive laws, and I'll for a moment take you to another civil law of women's rights in the workplace. And let's look at sexual harassment at workplace and this other law that I'm referring to, which is called Maternity Benefit Act, which is a labor law, right? So the Maternity Benefit Act has been amended in recent times, which allows women to seek 6 months of paid leave from her workplace for birthing and for taking care of the child and recuperating. We assumed the Maternity Benefit Act and the Sexual Harassment at Workplace law is going to benefit working women in a great way, in spite of the debates or whatever. And it came through. 6 months of paid leave came through. What was the reaction? The reaction largely by many, many organizations, especially private sector, is that women are a liability. Anyway, now, you allow the night work ban has been removed, so women can work at night. And therefore, you have to guarantee a lot of security. Now you have to give us 6 months of paid leave. On top of that, government employees are also entitled to what we call childcare leave. Oh my God, women are a liability. And she's also a bother because you never know when she's going to bring a charge of sexual harassment, and you will not even know why she will bring it. So the moment you want to change the social standards of what is acceptable behavior and non-acceptable behavior, what is equality, what is formal and substantive equality, there is a huge backlash by a given society, of a patriarchal society, which says that women have become a liability. So also we see that this tussle that continuously happens, which is law moving at a faster pace than what we call social conditions. And therefore, we also have to look at these claims that and all these claims have been made by the women's movements. So the claims of the women's movements that the law resonates with that, when the law acknowledges what the claims of the women's movements are, that also backfires in certain way. And we are seeing this happening with the Maternity Benefit Act, with childcare leave, etc., etc. That's already there. So the dynamics between women's movement on one hand and legal reforms on the other is um, is a multifarious one. At times, what the women's movements is making a claim, the law only partially responds, and all other voices are silenced. Sometimes the law responds, and the law responds positively from these claims from below, but the society reacts very violently. And sometimes the law simply does not acknowledge what the human rights movements want and completely plays to the gallery. And I think the death penalty debate is like that, something that the movement never wanted. But there is this claim of the collective conscience that rapists should be hanged, and that is what the law acknowledges. So this dynamics is very, very interesting. Let's come to a couple of other things which I think also does this. One is the entire question of child marriage in India, and I want to stop and take cognizance of what is happening. Let's look at what is happening. So very, very recently, we are seeing an amendment on the age of child marriage shifting from 18 to 21 years. And I think this is a new dynamic that is evolving. What is this new dynamic and what is common between the raising of the age of marriage of girls from 18 to 21 years and triple talaq? What is common? This ban on triple talaq. What I think is common in both of this is apparently they look very progressive. And I'm going to sort of talk about why I think it is apparently progressive and what do we need to think a little more. So let's look at this age of marriage moving from 18 to 21. As was also mentioned by Professor Kannabiran before, the age of sexual consent moving up from 10 years to 18 years as it stands now has covered a journey over 100 years, more than that, from the 1880s, right? So it moved from 10 to 12 to 14, and in 1978, the age of marriage for girls was at 18 and the age of marriage for boys was set at 21. Now, there was this equality debate that started coming in from a few years back, saying, why are they two different ages? So either you equalize it downwards, which is make the age of marriage 18 for both boys and girls, because that's the age of majority, etc., etc., or you raise it to 21 for both boys and girls. That is the other side, and we are arriving there. What had also simultaneously happened was through a law in 2012, which said that prohibition of sexual offenses on children. And that law said that the age of sexual consent also stands today at 18. The age of sexual consent prior to 2012 and 2013, the age of sexual consent for girls was at 16. Under the rape law, it stood at 16, right? Now it has gone up to 18. Why has it gone up to 18? Because the Prohibition of Sexual Offences Act says that the age nobody can have any sexual relationships with a minor. It prohibits, it criminalizes all sexual activity between minors and between a minor and an adult. So the age of sexual consent under POCSO is at 18, because the age of marriage is at 18, and therefore the age of sexual consent and the age of marriage is now the same, which is again a little bit of a problem. Age of sexual consent and age of marriage being the same, so anybody marrying a woman, a girl under 18 years of age, can be criminalized. and will go to jail. All these marriages are will be declared void, which is illegal or null and void. All these marriages, when you're marrying somebody under the age of 18. Now, this creates a conundrum where socially the girl is married, but legally her marriage is null and void, right? So there is a little bit of a problem there. We'll talk about this perhaps in some other occasion. Now we are in this position where the age of sexual consent is at 18. And now with this act, we are moving it to 21. And apparently, the state is saying, I don't know what this shifting of the age from 18 to 21, as I understand, has happened without any deliberations. Something that has been happening in India on any social legislation, that you have these rounds of discussions and deliberations with groups who are going to be affected. Without deliberation, the age is now moving up to 21. Apparently, it looks very progressive. Why? That women will marry later. Therefore, childbirth will be later. She will get a lot more chance of establishing herself she'll be employable and in certain circumstances. She'll be more independent. Will this happen? Because nowhere are we discussing about any public policy or any social policy which strengthens women's emancipation. We have the Beti Bachao, Beti Padhao. We know how social welfare legislations are cut down. There is the already existing schemes are seeing a rollback. So what will we gain by pushing this age of marriage to 21? So what will happen, which some of us fear, is that right now, the age of marriage being at 18, you can still convince parents to get their daughters to school till the age of 18. Now, the moment you shift it to 21, there might be this rush to get them married as soon as possible. That's one. Second is that if you're looking at data, the National Family Health Survey data is showing that the age of marriage in India for girls is actually steadily going up. It is nearly 18. It is going up. The age of having your first child is also going up. So it is actually progressing. In this circumstance, pushing it to 21 will not give any additional benefits. What some of us fear is that this becomes a ploy for resisting girls or young women from marrying a person of their choice, especially if that marriage is inter-caste, inter-community. So we have already seen the Hadia case, and I'm not getting into the Hadia case, which is when a 20-year-old woman says that I married somebody from outside my caste or outside my religion, and the kind of social backlash it has. Now this might give a legal stamp to it. And this will increase parental controls over women and girls. There is a lot of parental control over boys as well, but much, much less when it comes to sexual consent. So this just might become a ploy of resisting girls from exercising their sexual choices. It will also resist women in same-sex relationships to get outside their home with a partner of their choice and moving out, because you might just, say that this is prohibited. She cannot go away and start living in with another woman of her choice, right? So I think this 18 to 21 apparently looks very progressive, but we really need to weigh out what are these benefits of raising it to 21? Or will this mean more sexual control of women in an already repressive atmosphere? That is what we think. The second point, I think, is similar of state control and social control on the triple talaq, the prohibiting unilateral divorce of Muslim women by their husbands. When we are looking at how the media talked about the triple talaq debate, or how the court talked about the triple talaq debate, interestingly, we look at this debate coming from within the stakeholders themselves. So if you're looking at the triple talaq debate, it's interesting because, like the Shabarimala as well, into which I'm not going at the moment, it is clearly evidence of the fact that law cannot come from above. Laws have to be claimed, or changes in law or rights, legal rights, have to be claimed from below. So if you're looking at this, a very, very long discussion and very, very rich discussion held by the Bharatiya Muslim Mahila Andolan, then you will see that the debate was not only on unilateral divorce. If you're tracking the BMMA debates, you will see that Muslim women were talking about several other things. They were actually talking as women, as Muslim women, and as Indian Muslim women, right? So they were talking through multiple identities and through multiple intersectionalities, in the sense talking about patriarchy within the community, patriarchy outside the community, and also sort of, I would say, anti-Islamic stance outside the community. And they were talking as Indian citizens and Muslim women. And the debate was not only on unilateral divorce, but also on child marriage, polygamy, and very importantly, nikah halala. Nikah halala is another practice that allows a woman to sort of remarry, to divorce only through actually marrying another person, sort of consummating that marriage, and only then she can go back to marrying her, to re-establishing her marital rights. So all the nikah halala is also a retrogressive practice within Islam that was resisted by Muslim women. Interestingly, the triple talaq debate does not talk about any of that. It only selects triple talaq, criminalizes triple talaq. And that is the last point that I wanted to make. The criminalization of triple talaq was not demanded by the BMMA or by Muslim Women's Organization or by the other women's rights and feminist organizations that were also supporting Muslim women's organizations in India. There was no discussion of criminalization. What it was saying, the claim was that through judicial decisions, you could get triple talaq to be unconstitutional. You can declare it unconstitutional, and that's it. What was the need for criminalization? What does criminalization mean? It means that a man who declares talaq, talaq, talaq to his wife, which is anti-Islamic, now also unconstitutional, will be criminalized and will go to jail. Did the women's movement, the human rights movement, the Muslim women's organizations wanting this? I guess no. So is the state overstepping its boundary, actually doing things that the movement didn't want? And yet, when the BMMA was talking about, other practices like child marriage, like nikah halala, that were not entertained, and said that, no, let's just look at unilateral divorce. The rest will come later. And now all of these practices and several other practices on the basis of, when women are being discriminated on the basis of religion has now gone to a Supreme Court constitutional bench where all of these questions will be looked at simultaneously, not looking at them separately, but all of these religious practices that discriminate women will be looked at by a constitutional bench. We will have to await that judgment. Let's not get there now. But this is interesting. Why was this overstepping or criminalization of Muslim men done? How will that help? By putting men in jails or by putting people in jail? Is criminalization the answer? Is something that human rights groups and feminist groups have been questioning for long. We have been long resisting the idea of death penalty as deterrence. And also we need to understand how does criminalization benefit women and other genders? Or does the answer lie elsewhere? Women's rights groups have continuously and consistently asked for several procedural reforms. Instead of saying death penalty, human rights groups and women's rights group in India have, since the 1980s, have consistently said, let's have surety of a trial. Make trial certainty, not really punishment all the time. Certainty, time-bound procedures, victim compensation, and witness protection. Why is it that in several cases, especially when it is a case of human rights violation by a powerful person, do witnesses go hostile? We have seen this in many, many cases, especially when it involves cases of Dalit violence and violence on Dalit women, something that Kalpana had already discussed. Why do women go hostile? Because they know that they have to live in a village where the powerful upper caste will make their lives hell if they go and depose in court against them. Their lives have not changed. Why is it that trafficked women and children do not depose in court against their traffickers? Because they know that traffickers are very, very powerful. They know that they will not get that, rehabilitation in their own houses when they are, rehabilitated back to their own environments. So what happens to, witness protection? What happens to the woman who is deposing against her husband in court in 498A? Where will she go? Where are these shelter homes, safe homes for women? Why do women live in violent relationships? Because it's not because, the law is always so bad. The law may be great, but it will take 10 years. Second, she knows that there isn't a place for her to go. If she is bringing a criminal charge against her in-laws and her husband, this will be followed by a divorce case and a case for maintenance and a case for custody of her children. Can she fight 4 legal battles? So 498A, which patriarchy says that women misuse, doesn't come easy on women. It is followed by 3 other cases simultaneously that she has to fight. All that women want is to stay safely. But if she wants to get out of the house, where are these shelter homes? Where are these safe homes for women? The women's rights groups have been talking about this for very long. Increased employment for women. What have we seen in India? Decreasing employment for women. If you're looking at the global gender gap reports, India's position is really low. We are worst on employment. The gap between men and women in employment is one of the biggest, right? So all of those things that the women's movement have been demanding, procedural things, implementation of social policy, better codes, better economic provisions for women, all of this hasn't come through. What have we decided? More and more criminalization, more and more harsher sentences, as if they are going to solve the problem, which it hasn't. Harsher the sentence, the more, when the moment you want to award death penalty, the court will naturally look at proof beyond reasonable doubt, because you're going to take a person's life now. So the benchmark for declaring a person guilty will also go up. That has also happened. That is why you have less conviction. What has also happened is that the more you push for harsher sentences, and this is something that we are witnessing now, which is you want to remove the witness, which we have seen in cases of rape of children and women, which is rape and murder. You want to remove this person from society because this girl will go up and depose against me in court and I can be hanged, is what the rapist is thinking. So remove her, kill her. And successively we have seen, apart from not only legal evidence, apart from the fact that there is this, we live in very, very violent times. And we are seeing in multiple cases in the recent past, rapes are also followed by murders of young children with the POCSO, of women, and also clearly with Dalit women. Because the fact that they are going to a court itself to depose against a powerful man is that they are challenging societal norms. So, the remedies do not lie in criminalization. The remedies do not lie in apparent progressive legislation, but we need to think is there another reason for doing this? Should we look at it from another lens? And I really think that we need to look at the raising the age of marriage and also the criminalization of triple talaq through those lenses. That is, I think, which is important. Finally, to end, and I don't want to sort of stay there for long, which is that we have only discussed women, but if we are looking at the latest judgment on queer rights, which is Navtej Johar, which now decriminalizes 377, this will, the next round of demand that the queer movement will perhaps is seeing and will see is what we call civil union rights. The right to quote unquote marry, I'm not using the word marry, but the right to cohabitation, the right to inheritance and property, everything that accrues to heterosexual couples should also accrue to same-sex couples. Is the Indian society and the Indian legal system prepared to take that on? So all that, the win is only decriminalization of 377 or a partial reading down of 377, not only complete decriminalization, a partial reading down of 377 when it comes to consensual sexual relationships amongst same-sex couples, adult couples in private. So it has a lot of caveats. That is the only thing that we have done. And this will lead to several other things, which is unionship rights, inheritance rights. I think the Indian legal system is not ready to take on that. We'll have to prepare ourselves for that. The other is the Nalsa judgment, which says trans people in India today are legal citizens. What are we doing about that? State after state, if we are looking at what the gains have been from the Nalsa judgment in 2014 to we'll be entering 2021. So a period of 6-7 years. What have been the gains of trans persons as equal citizens? Have our workplaces, our educational sectors opened up to trans people? Have our schools opened up to trans children? I don't know. There is very little data on that. So we also need to understand that you can have a very progressive judgment, but what about, are we following it up? And that's the last point, that, the women's movements and the human rights movement cannot just sit down and think we have won a round of battle. We are losing a lot of battles, but that's a different discussion, I think. We just have to continuously, push for more and more accountability and transparency, more and more reflection. We cannot, at any point of time, sit back and think, okay, now this struggle, this round we have won. The rounds are incessant. One round has ended, we might have a little win, but the losses are greater. So let's beef it up. So the struggles will have to continue. And that is what we need to keep on doing. There is not a moment where we can sit down and relax. I think the struggle will be on forever. And we all have to be in this struggle together. Thank you very much for all your patience and for bearing with me. Thank you.
To be very precise, I'm really overawed by the two fantastic speeches, fantastic deliberations, and thank you, Ruchira. And actually, I was so involved in your speech. Well, you have covered a lot of area, starting from domestic violence, and the area is really vast, vis-a-vis law and the legal structure. And actually, let me start with your deliberations involving pandemic and the discriminatory role of pandemic. It is no longer a leveler. Actually, the predicament of women were really extremely pathetic. It increased domestic violence, it increased child abuse, child trafficking, child labor, what not. Women are not monolith. You have referred to the intersectionality, and you have mentioned the shift from colonial to post-colonial lawmaking process. There has been a paradigm shift, but the hangover was still there. Law being modified, but experiencing law gives you another idea altogether. It is gendered. Ultimately, laws are gendered. When the very dichotomy between good women and bad women, good repped women and bad repped women, referred to the case of Susan, really shocked us terribly. Any individual citizen having a little bit of conscience will get horrified, will get shocked by the very reactions that we have experienced from a particular section of the people who have tried to dub or identified Susan as a bad woman. Anyway, the collective response, you have referred to it, and the very idea of the public conscience sounds so hollow when it comes to the question of Dalit women getting raped. You have mentioned about the egalitarian law under the constitution, which really encompasses formal equality, but you have talked about substantive equality, the legal provisions therein. Actually, from de jure to de facto equality you talked about. Civil law are, well, problem is that the civil laws are always mediated through religion, absence of real secular law that is very important in discussing or any socio-political discourse. With the question which related to anything related to sexual assault case, I believe the area you have covered is wonderful. Wonderfully vast, and the Special Power Armed Forces Special Power Act, and we have seen what happened actually in Manipur. We can never forget that gruesome incident. Women rights groups are really demanding justice for the rape victim, but certainly they are not asking for death penalty, because death penalty is not a particularly useful deterrent. On the contrary, what happens, you have just mentioned, that the perpetrator of violence will try to kill that particular victim, because unless they can get back to the judiciary and lodge their complaint and report, it's not possible. It's not possible for them to accept it. They kill them straight away. You have mentioned the Babri Devi rape case, where the Bishaka guidelines, uh, the Verma committee report, and their interaction with people, women's rights groups, and you have really ridiculed the claim by the policymakers that they have made some progress with regard to marital age or sexual consent age, because really it is immaterial if it is raised theoretically, because ultimately certain provisions are lacking there which can ensure a steady progress in ensuring gender justice. And it's a fantastic experience we had for the last 2.5 or rather, I don't know how much did we take. I'm not keeping any look at my watch anyway. Experience was fantastic. I'm really grateful to both the speakers, and now I will hand over the proceedings to Orithro so that the question and answer session may begin. And really, I'm really grateful to you for giving your consent for addressing this particular webinar. I believe the listeners have greatly benefited. Thank you very much.
Thank you, Dr. Shyamadanda Majumdar, for summarizing the session so beautifully. I am grateful to both the distinguished speakers for enlightening us on so many different aspects. We have a number of questions, but before I begin, I would note that Dr. Goswami has already answered some of them. I think there was a question on the triple talaq bill, and there was a question on increasing the age of women's marriage. So those have been answered to some extent. I think a lot of the questions that we received are actually covered in the speeches themselves. That said, I would draw the attention of the speakers to some questions that have come in directly to us. They are not there in the Google Meet. So I would now share my screen, and I have them in my email. So I'll just share it directly. Is my screen visible? Are the questions visible? Can someone confirm, please?
Yes, the questions are visible. I can
Thank
see.
you, ma'am.
Yeah.
Ma'am, so there are 4 questions. I think 3 of them are directed to the panel, both the speakers generally. And there is one question, the third question regarding experience in teaching law, which is directed to you, ma'am, Dr. Goswami directly. So I think we can take these up first. Should I read them out?
No, I can see. Yeah.
Yes, ma'am. I open the floor on the speakers to answer these questions as they would prefer to.
So which question do you want me to answer? The one that says to RG, the experience of teaching law, or the other ones as well? I don't know.
Ma'am, it would be better if you start with that one, because that is
Okay.
directed to you personally, I think.
Yeah.
And then we both can answer the remaining questions as the see.
Okay. So thank you. So this experience of teaching law is kind of interesting. I mean, of course, it is an androcentric nature of the discipline. I've been teaching in law school for a long time, and perhaps Kalpana can also bear me out. She has longer years of teaching at the law school as well. It's kind of the problem that women's studies have also, in the sense that, does it stand alone as a separate discipline, or is it mainstreamed within the other social science discipline, and law suffers a little more? And it largely, I think, depends on your pedagogy and who the teachers are, whether they are initiated into gendering the law and understanding the law from a gendered perspective. I can only speak for where I teach. I can't speak for all law schools really, but largely thinking, I think that there are a bunch of teachers who sort of engendered the law, in the sense that for any discussion on any legal part, you bring in a gender perspective or a class perspective or a caste perspective, so that you sort of address the law beyond positive law, and you look at the law not as an insular discipline and a practice, but you inform it through other social science understanding. My understanding is that there is always only a handful of people who do it. It has changed over the last few years from resistance to doing gender to acknowledging that doing gender is important, but often it is lip service, and most of the time it is not mainstreamed in other courses. Some courses maybe, but that largely depends on who's teaching the course, what is that person's perspective, but not really always formally through the curriculum. No. And I think this is not particular for law only. I think this is also true for other disciplines as well, which is you do gender in your paper, huh? So let the rest of the teaching, let economics stay the way it is. You do not want to do feminist economics, or if you do, it's going to be just a little minute part. It's like jurisprudence course, you know. Do you really have to teach feminist jurisprudence? Acha, so just take 3 classes and do feminist jurisprudence. You know, that kind of thing keeps on happening. But it's changed because in certain law schools, I know that there are many more teachers who are teaching law through a gender perspective. So the androcentricity of the law has been challenged, especially with a lot more people interested in sexuality studies than 10 years before. So for me, it's like that. I think it's a mix. It's better than before, but it's far from desirable. At least that's what my experience is. Yeah. I'll stop here and then over to.
Thank you, ma'am. Ma'am, would Dr. Karnaviran want to weigh in on some of these questions, or
Yeah, what I'll do is I'll just do a response to address all the questions in one segment, and then Ruchira can come in on the others as well. To take off on what Ruchira started about teaching in a law school, I taught in a law school a long time ago. And I taught there for a very long time. I taught for a decade, but that was a decade ago. I would like to assume that things have changed. But there are two parts to this. One is that in the social sciences and humanities, at the time that I was teaching, you already had a high presence of women on the faculties, whether at the degree college level or at the PG level and so on. This was not the case in law schools. So there was, and I do think that it is important. It makes a difference. Not to say that women have, not to essentialize the problem and say women have, an automatically feminist perspective, but it just makes, diversity in the constitution of the faculty makes a huge difference to the way in which we might understand or engage with the law. The question of diversity is important, and my experience was that law faculties and law school faculties were not diverse. They're not as diverse as, for instance, the faculty in the social sciences and humanities. I wouldn't say the same thing of the sciences, but in the social sciences and humanities, the fact of social diversity was much more, not just on gender, but on a number of other indices as well. So that was a beginning of the problem. The second part of the problem is that in law schools you are meant to teach the law, and the law is understood both in terms of enactment, which relies on legislative bodies, and implementation, which relies on executive bodies, and interpretation, which relies on judicial bodies. The related question, therefore, is not only how do you teach law in a law school, but who are the Johnnies who are making the laws? And they're all Johnnies. I mean, please don't forget that we have resisted women's representation in parliament for as long as I can remember, and it is still not a reality. Who are the Johnnies who are implementing the law in the executive? What is the share of women? What is the proportion of women in the executive, in the civil services at every level, the IAS, the IPS, and the state services? And of course, the proportion of women in the judiciary, where it is a pyramidal structure with a larger number of women represented in the district judiciaries. And as you move from the district to the High Court to the Supreme Court, it drops to an abysmal 1 or 2. And there was a Supreme Court judge who went on record to say that there is an unwritten rule in the Supreme Court that there will only be one woman judge at a time. So there is another woman judge who's waiting to be elevated, but she has to wait till I retire. This was a sitting Supreme Court judge who said it. Now we've bettered that proportion to 2, but it's still only 2, you know. So the question of teaching law also depends on on these other fields that the law must that a law teacher must teach. Yeah, so it's not then surprising that a judge in the high court comes up and says that bringing constitutional law into the family is like a bull in a china shop. I mean, these kind of quotable quotes, misogynist quotable quotes circulate right from then to Suresh Kumar Kaushal and beyond. And this is the law that you are meant to teach. Yeah. So whether the law as enacted, where the parliament has refused to remove the marital rape exception, or it is a question of implementation, where the criminal justice system, particularly the police, have been notorious for derailing existing law, as we saw in the recent sexual assault of the veterinarian in Hyderabad, where the accused were simply taken and encountered in a brazen, brazen act of death penalty by other means. So we don't really need the Supreme Court or any court at all. We are a court unto ourselves, say the police. Yeah. And then you have the judiciary, which has delivered very, very mixed. It's a very mixed bag. And these judges are all men. I mean, they are, let's face it, they are all men. So let's start talking about feminist jurisprudence by first talking about diversity, without essentializing it, without saying, no, women will do good to women. First, let's talk about whether men are doing good to women. Let's settle that first. And are men doing good to women by actually stepping back and allowing women, their half place under the sun? Yeah, because equal representation is a constitutional requirement, but our courts and our parliaments are exceptions to that constitutional requirement. So where states of exception are normalized, the task before a teacher in a law school is rendered that much more difficult, if not impossible. Because you're not only speaking about how the law is engendered, but you're also having to explain why the law is engendered in a particular way. And in simply stating that, you are risking contempt. Yeah. And we know now from the travels of Prashant Bhushan what contempt means. Yeah. So by definition, speaking about the implementation or the interpretation of the Constitution is contemptuous. Yeah. But it still, I think, does not take away our responsibility as feminist law teachers to risk contempt on an everyday basis in the classroom. And I think we have done that. Minuscule. I was in a situation where the task of teaching criminal law was given to a judge, a retired district judge, who had come to teach criminal law. Now, the one thing that I will grant is that it is the district judges and not the High Court and the Supreme Court judges who know their criminal procedure. Whether they implement it or not, their training in procedural laws is much more rigorous than the training of your High Court and Supreme Court judges. And we have found this time and again in relation to a range of criminal legislation. But like the High Court and the Supreme Court judges, the male district judge comes with his own baggage, a gender, patriarchal, misogynist baggage. So this gentleman would go into class and say, I don't need to teach offenses against the body, and you don't need to learn offenses against the female body. You just don't need to. No, all that you don't need to. That's not necessary for criminal law. And I got myself onto his course and said, I will teach whatever you don't want to teach. So my task was always a residual task, that I teach what you don't want to teach. The minute I did that, and I put sexual offenses right at the top of my agenda, students started giving him trouble in his class, asking him questions about criminal procedure that related to sexual offenses that I had taught. And when he refused to answer them, then they gave him more trouble. And so he went and complained to the head of the institution that he doesn't understand what I have done, but I have just gone and mesmerized these students. So teaching sexual offenses is interpreted as seducing the students away from procedure, from hard procedure. I just told the Vice Chancellor, well, I actually don't mind that description. It's all right. I mean, if that's what he thinks, it's all right. I will continue to seduce. If it means helping students to understand differently, to appreciate interpretation differently, to look at the law with a different lens, if that is what he means by saying she is mesmerizing, so like it's like the Pied Piper leading students away from the paths of law and justice. And so I did that. I did that for labor law. I did that for constitutional law. Article 17, which is in the fundamental rights chapter, was never taught in constitutional law. So I taught Article 17 in class. I taught 15.2 in class, long before Naz made 15.2 popular. I taught 15.2 in class. So the point is that you have a largely what black letter law teachers would consider as residual category. You have largely a residual job, but what you may do, and I have actually seen that with successive batches of students, what you can do with that residual approach to law is to completely turn tables on black letter law. Because what students go away with, is you're throwing a spanner in the works. They go away with that spanner. And that spanner they never lose hold of, because it comes back to them in the most unusual circumstances.
Absolutely.
And I have seen evidence of that with students who have gone into litigation and managed to use that spanner in such amazingly creative ways. So ultimately, it's just that one person, like Margaret Mead says. You don't need a whole lot of people to change the world. You just need to be able to sow that seed of doubt.
Exactly.
And that's, I think, basically what a very small handful of us have been doing for very many years. On paternity leave, very quickly, I think, of course, paternity leave is important. And I think, of course, fathers must be given paternity leave. But that's not enough. Fathers can't go home and just put their feet up and watch TV or write papers on paternity leave. They must relieve mothers from doing overtime duty on neonatal care. The question is, have we taken an audit? Do we know that that is what fathers who claim paternity leave are doing? The test is there. On a formal basis, of course, fathers must be given paternity leave. I have no doubts and no second opinion on that. But I think that is on a formal basis. What we still need to move beyond is the substantive requirements of paternity leave. On child marriage, I will give you another, an anecdote, really. I don't think that these population arguments hold water at all. But when the Indian government appeared before the UN CEDAW committee in New York in 2007, the Attorney General of India went on record to say, if you make child marriages void, it will increase the number of illegitimate children in the country. This was the official response of the Indian government. So I think that we will have all kinds of bizarre and whatever arguments against for and against child marriage. But our basic argument is, what is it that is in the interests of personal autonomy, the right to choice, and dignity for adolescent girls who are forced to enter marriage? Where does consent figure? And then, of course, there are the more difficult questions of consent related to adolescent sexuality. Not necessarily marriage, but adolescent sexuality. So this is a really very complex question that we can't narrow down to illegitimacy or population control. These are status discourses. And we need to sidestep status discourses when we talk about questions of autonomy. Yeah, I think I'll leave it there. Thanks.
Thank you, ma'am. Would Dr. Goswami want to comment anything on the questions? All these 4 questions, she has already answered one.
Okay.
The 3 one.
Right. I'll just quickly come on the question that has not been addressed, which is some women's voices and journals on the first debate. There are many. There are many articles on age of consent debate of the 1880s, but just 2 quick things that come to my mind. One is this book by Sudhir Chandra called Enslaved Daughters, which talk about the Rukmabai story. And this is a very interesting story, is that, whenever we look at social and legal reforms, we look at it that men enabled, so when we talk about child marriage, the first raising of age, we talk about social reformers who have all been men in the 19th century. And the Rukmabai story is interesting because she is a woman who resists consummation of her marriage, and she raises these questions of consent in 1884. She says that, nobody asked for my consent when I was married off at the age of 10 to a man I did not want to get married to. And as a 10-year-old, what would my consent mean? So in 1880s, for a young woman to say that nobody asked for my consent, and what does consent mean, is unthinkable. Um, uh, Sexual consent of women and also men in the 19th century was unthinkable. So, and I think the Rukmabai story is a fantastic story of, these voices that we don't hear. So when we study history in school and social reform, we talk about, Vidyasagar and Ram Mohar and Dayanand Saraswati. And that's not to belittle anyone. Of course, they were great contributors. But what about women's own experience? And, as Kalpana had talked about, so many stories, of Bhavri, of Mathura, of Soni Sori story, whom we didn't talk about. For me, the Rukmabai story in 1880 is a fantastic story on consent. So that book, I think, sort of talks about that, and I think that's an interesting way of looking at women's voices in the 19th century on marriage, on Hindu, and the other is this book on women and social reform in India, edited by Shumit Sharkar and Tonika Sharkar, which talks about women and social reform. Partha Chatterjee's woman question. How do we understand the woman question in law? I think these are and they all refer to the Hindu Code Bill debate. I think would be good good articles and good books to start with. I have already talked about this the population control thing when I was presenting, so I'm not getting into that. I completely agree with Kalpana on the first. The paternity leave should be given, and there were just my anecdote that when we were discussing paternity leave, I had three of my colleagues, male colleagues, who responded very, very differently. And I was very intrigued by the responses. So one colleague simply scoffed the idea of paternity leave and said, "Why do you need paternity leave?" What? So that was one. The second man said, "Oh, paternity leave is a great idea." And when I asked, "Why do you think it's great?" he said, "Because, oh, great, because if I get this 21 or 15 or whatever it was, 10 days leave, I can go home. I can finish my unfinished articles that I have to write." So he supported paternity leave for a different purpose. The third man in the group said that, of course, paternity leave is important because I want to take care of my newborn child, and that is why paternity leave should be given. So there were very different responses by the men, by three different men. So I think paternity leave is very important, has to be given. We absolutely agree that we need a social audit. We don't know what men are doing with the paternity leave, and we might just think a little beyond and look at Scandinavian or Canadian legislation, not around paternity leave, but something what they call parental leave. So you just gender neutral. Sometimes gender specificity is important. Sometimes gender neutrality might work. So when you say parental leave, and you distinguish it from maternity, in the sense that maternity is not only for taking care of the child, but also for the mother to recuperate after having given birth to a child. In case of adoptive mothers, very clearly you need to have paternal leave for adoptive parents as well. I completely support. I think in India, it's a very, very problematic position when you say that if you have adopted a child, you won't get as much leave. We can get into that discussion. So One is that you can have parental leave, which is gender neutral. So both parties decide how much time they're going to spend on the child, and then you it need be right after the birth of the child, but over a course of time. I also think, along with paternity, this entire thing about childcare leave is also very complicated, because it only assumes that women are there to take care of children, which might all which is also true. So I'm not disputing the fact that more women take care of their children, but for a law or a policy to say that women are the primary caregivers is a problematic position as well. So we also need to figure that out, and then, as I said earlier, that the moment that woman says that, as a government employee, she's entitled to 730 days of leave, often she is looked at as a problem, as a liability in the organization. I have a problem with this how it backfires in this, right? So yeah, we can explore parental leave ideas and see, but we need social gender audits and social audits for all of this. This is a huge problem. Yeah, I'll stop.
Thank you, ma'am. Thank you, ma'am. These are the four questions that came outside of Google Meet. I'll just stop presenting and we can go back to the very long questions that came in Google Meet itself. So the first question was by Dr. Samata Vishwas. I think it has been largely answered by the speakers. But if they want to reflect, they can definitely answer this question again. There is a very long question by Guinea Adamastos on the Justice Burma Committee report. Then there is Choitali Kormukar's question. Choitali is an alumna of our college, Shivnath Shakti College, and she has a question regarding the male spouse. And finally, there is Dr. Dipankar Bhattacharya's question. Dr. Dipankar Bhattacharya is Associate Professor of Political Science in our college. He also has a question. So I think if the speakers want, we can pick up these questions, these four questions that are there in the chat section of the Google Meet.
May I request Kalpana, you can go first.
So you can answer as you want to, ma'am. I think Shamala Vishwa's question has been answered to some extent. So, Guinea Adamas's Justice Burma Committee report, government lack of sensitivity on this question, role of women's groups on this question. Other
Yeah,
speakers
well, Dr. Dipankar Bhattacharya's question I have answered. I did look at the judiciary, the gender question in the judiciary, but he says his question is to Dr. Goswami. So, yeah, my response is there already. Chaitali Karmakar. Well, I think the question of blackmailing and so on at the hands of the female spouse, we also have men against domestic violence laws and men against abusive women. I think they're in Calcutta.
Yes.
And there have also already been studies. I mean, women facing domestic violence, it took a long time for studies to come out and so on. But I imagine, if I'm right, that there are already studies on the politics of men's rights groups. I would actually refer you to those studies, and there are also demands from men asking for a change in laws and for recognizing the male as victim. Without falling into the trap of the de minimis argument saying, no, there are too few men who are complaining and so on. I think that, anybody facing abuse and violence in the family must have access to redress and protection. And this goes for all people in intimate relations, irrespective of gender, male, female, queer, LGBTQ, whatever. There must be protection against abuse in intimate relations. How will this be accessed? Our domestic violence laws are not gender neutral. They provide protection for women, for the elderly, and for children. For the moment, they will have to take recourse to criminal law, and I do believe that criminal law does have provisions against battery and abuse. But as a basic thumb rule, I think I would just like to state that abuse, violence, torture. In fact, Wahida Nayanar has argued very persuasively that why is there a reluctance to consider domestic violence as torture? And she's, of course, argued the case with reference to women because the largest volume of cases of very gruesome torture has been documented in the case of women. I have not actually seen a documentation of cases of torture against the male spouse, and I would be interested. I mean, rather than a rhetorical question, I would actually be interested in looking at, however few they are, looking at documentation of the exact nature of abuse against the male spouse, because I think that any observations that we make must be informed by looking at the documentary, by looking at details, testimonies. I'm not even talking about evidence, I'm talking about testimonies, yeah, that are based on factual experience of such violence. So absent that, I can only make a general kind of statement that, that violence of any kind in intimate relations is bad and must be condemned unequivocally. On Genia, this well, I mean, even this I answered. I mean, I'm saying that the point is that you have an extremely gender exclusionary legislative, executive, and judicial environment. And so it's not only in terms of the gender attributes of the bodies that inhabit these environments, but also the mindsets that they carry. Look at our parliament, I mean, look at the way in which they debate questions of gender. Ruchira went at length on the question of triple talaq. But then, although much has changed in the last 40 years, the one thing that has not changed in parliament is misogyny. That has been a given. So, of course, they won't take the gender progressive elements of the Verma Committee report. I mean, that also was a given. The fact that the Verma Commission sat and the fact that they listened to this large cross-section of opinions, including from feminists on what rape laws should look like, that was our victory. But I don't think any of us fooled ourselves to thinking that what the Verma Committee put in its report is going to directly be transported into law. We were not under that illusion, certainly. I was not under that illusion. Yeah, because for that we need a structural change in the way in which these bodies are constituted, our lawmakers and our interpreters and our implementers. Yeah, thanks.
Thank you, ma'am. Would Dr. Goswami want to comment on these questions?
Right. I actually also talked about the Verma Committee quite at length when I was discussing. Again, I actually said that there were many claims and many of them were not met, but sort of to say that it did not lead to, which is the question here, that never resulted in something substantial practically. I don't know how to interpret the word practically, but in terms of the changes that came in the Criminal Law Amendment Act, there were many things that the feminist groups had asked for and got reflected, right? So, for example, this entire business about acid attack, which was out there in India, and there was no penal provision at all, right? So, you can die out of acid attack, or you might be scarred for life, but there is no provision in the law. We are not trying to say that by providing it in the law, you automatically getting recourse, but the legal acknowledgement of the same. So very interestingly, I thought was very interesting was not acid attack, but things that were culturally understood as given. Things like stalking and voyeurism. The stalking and voyeurism is understood as a kind of a dating way of courtship in India. You watch Bollywood cinema and also Bangla cinema. I have only access to these two languages, unfortunately. And you will see that, like if you want to woo a woman, first of all, sort of you stalk her. And that has started from Devanand's time to Hata Poster Nikla Hero kind of cinema in 2006. So you stalk a woman for long, doggedly, and she will come around, right? So that, and feminists were resisting this, right? And saying that you have a provision which stops stalking, and stalking is just not wooing. Also voyeurism, when we say peeping Tom, or out, we use words like eve teasing instead of calling them molestation. And women's groups have continuously talked about legal language, sexism in legal language, and said that these are not acceptable. Voyeurism is affront on my dignity and my privacy. You just can't say peeping Tom, right? So the rear window kind of cinema can be challenged by this peeping Tom, right? And I think all of that was accepted. And these were all reflected in the Verma Committee that got also translated into the law, into the Criminal Law Amendment Act. Disability rights groups made a lot of demands. Some of them partially got reflected. This warrants a different discussion. I'll not get there. But for the first time, we are acknowledging the differential experience of women with disabilities in a court. And all of that also got reflected. What we all thought, as Kalpana said earlier, that the most complex one, which challenges given strong hierarchies, will not change. For example, marital rape. For example, impunity of the army. The might of the state in death penalty. This is, Nivedita Menon in one of the articles in Kafila wrote something that I found interesting. All the citadels of patriarchy are intact, is what she said. All of these did not change. So we were all apprehensive that these are the ones which are the niggling things that will not change. Marital rape, we were thinking that it might not. Most of us thinking that even this will not go through. But the rest went through. So I let's not say that nothing got acknowledged. But I think the ones which were the challenging masculinity and patriarchies and the most stranglehold of them, those remained intact, is what I think of from the Verma Committee into the Criminal Law Amendment Act. Not that nothing got through. As far as Choitali Kormukar's question is concerned, this is interesting and a complex question. There is some documentation that is coming in. I have not followed it. It is documentation with a lot of misogyny brought in together, is what the Save the Family Foundation is doing, which is a national organization. The Pidito Poti Shongoton, which is in Bengal, is doing. Srimati Basu is working around these men's rights groups, so that might be a work that can be explored. But very interestingly, on the basis of sheer anecdotes, the 498 law has been watered down. The PWDVA has been watered down. From the Protection of Women from Domestic Violence Act said that you cannot, one woman cannot bring a case against another woman alone. That position has shifted. In 498A, the Malimat Committee had come out with this report that, this is being misused. There is no data on misuse. Point well taken. That we are not saying that there cannot be misuse, but let's look at who are these women who misuse the law, right? They are women who have to have several kinds of other social capital, right? But there is no data, as Kalpana was already saying earlier. Where is the data on this? So point very well taken that there can be, so we are looking for testimonies, etc. At this point of time, you cannot use the domestic violence laws, but maybe other kinds of laws where of criminal laws or other kinds of laws of where you can challenge these in court. You can move for bail, all of that, anticipatory bail. These kinds of positions, I think, can be taken already in the law. There are provisions. There are other provisions in the criminal laws that can be used by men for emotional or financial harm, etc. That they can say. Blackmail is criminally prohibited, right? So one can use those provisions in the law, I think. Manhani mamla, as we say, those things can be done. But we really look for testimonies. It's very complex. It's a slippery slope. I think I have answered the other questions, right? So, the other question on successive benches in Supreme, I think this was absolutely answered by this. We are not getting into biological essentialism by saying that instead of all men, if the committee were all women, they would be very sensitive. This is just biological essentialism. It's very clear that patriarchy hasn't got anything to do with what the body is. It's not the male body versus the female body. It's patriarchy is something that you practice. So, but what I think, what is more important is something that is also true for the parliament, which is you need to have a critical, or what Kalpana said for the parliament, for law teachers, you need to have a critical number of women in courts and in position in the judiciary and in higher positions in the judiciary. That is what we call the critical mass. Only if you have the critical mass can you challenge certain established gender norms. If you were this one judge in an absolutely male space, if you are this one senior police officer in an absolutely masculinist space, then they emulate what the men do, because otherwise, you would be taken as less serious. When women practice other kinds of quote unquote feminine values of inclusion, of being, not reacting violently, but listening, this is actually we are understood as not being taken seriously. So you need a critical mass of women to change the dynamics. When you see a lot more women, who are articulate, that does change. So I think it is important for more women to be in the judiciary, in the police force, in administration, in the parliament. But just having women will not change. This is a very, very long discussion that we had for the panchayats, for the parliament, the 33% reservation, for the police force and the judiciary. What we need to also change are the values of androcentricity that comes in these spaces. Those values, those practices need to be challenged by these women. And also that women are not a monolith, which is also a debate that came during reservation in the parliament and panchayat. Which women? What kind of articulation? Is it typical upper middle class articulation, or also articulation by Dalit women? A debate that came in the panchayat. So those kinds of diversities need to be seen, just not women, all kinds of diversities. what is the percentage of judges who come from Dalit backgrounds, male, female, irrespective, in the courts? So we need to sort of change all of this upper caste, upper class, male, privileges that are there in all positions of power, including academic institutions, not only in the courts. All of that needs to be. So that is changing, and I think just not only talking about biological women, but who these women are and what principles what feminist do they carry, feminist principles, or do they at least carry principles of diversity and inclusion into these spaces? I think those are the more important question, not just the biological idea of having men or women. Yeah, I think that's my answer.
Thank you, ma'am. I believe Dr. Kannaviran has had to leave for some reason.
Okay.
Anyway, actually, I saw that she left the Google Meet. I don't know whether she has some technical issues or anything. Anyway, I think Dr. Kannaviran has answered the questions, and Dr. Goswami has also answered these questions very exhaustively. And I particularly find the anecdotes, the experiences that they have to be very interesting, because these are things that we generally don't get in a textbook or any in the data that comes in. So I think the questions that came up were very interesting, and we have had a very enlightening, very enriching question answer session in which many new things, at least I learned very new things, and I'm sure the participants, the people who asked these questions also received the answers they were looking for. Now, without further ado, I would call upon Dr. Moshe Mondopadhyay, Associate Professor of History, Shivna Shastri College, to deliver the vote of thanks. If you're there.
Yeah. Good afternoon. After a very well coordinated and crisp question answer session conducted by Professor Orithro Mojumdar, now it is my proud privilege to sum up the day's proceedings and give a formal vote of thanks on behalf of the organizing committee. I would like to begin by quoting Gloria Steinem, an American feminist, journalist, and social political activist. A gender-equal society would be one where the word gender does not exist, where everyone can be themselves. And the ultimate truth is, as we all agree, that gender equality basically begins in the mind. It is no doubt an individual's perception of treating another person at par with himself or herself. It does not happen in one day. It's more of a practice that you do every day. Gender justice is considered as a human right. Every woman and girl is entitled to live in dignity and in freedom without any fear. Gender justice is indispensable for development, poverty reduction, and crucial to achieving human progress. Gender equality is intrinsically linked to sustainable development of any nation and is vital to realization of human rights for all. The overall objective of gender equality is the society in which women and men enjoy the same opportunities, rights, and obligations in all spheres of life. After independence, the founding fathers of the nation wanted to reform the society and were keen to establish an egalitarian society. The Constitution of the independent India grants men and women equal rights. They used law as an instrument to check the gender discrimination. A number of laws were enacted to meet this end, but due to strong patriarchal mentality and an unfavorable social environment, they failed to accomplish their goal. As a result, gender disparities remain. The social engineering through law was not fully achieved. While some rights enshrined under the enactments were enjoyed and accepted by the society, most of them remained only in papers due to lack of public support. Gender discrimination and gender justice is a prime concern of ours. And in this pandemic situation, when every problem has multiplied manifold, we are trying to explore the issues in a different way. Today's webinar entitled Inequality, Equity and the Law, Myth of Gender Justice in India organized by the Departments of History, Political Science, and Women's Studies in collaboration with IQAC of Shivnath Shastri College, is a step in that direction. Our esteemed speakers for the day, Dr. Kalpana Kandaviran and Dr. Ruchira Goswami, have enriched us immensely through their deliberations, which were rich in content and crisp and thought-provoking. Both of them being activists, have dealt the issue at length in a very efficient manner and highlighted the legal and social aspects of gender justice in our country. Their insightful, erudite, and meaningful analysis would enlighten us to a great extent. On behalf of the organizing committee, I take the privilege to offer my heartfelt thanks to the distinguished speakers. I would like to take this opportunity to thank Dr. Runa Vishwash, Principal, Shivnath Shastri College, who had been a constant inspiration to our endeavor as the chief patron. Dr. Shyamolendu Majumdar is to be thanked profusely for moderating the entire session immaculately and giving his valuable inputs. I would also like to thank Dr. Shamata Bishwash for giving a very apt introduction to this webinar. Dr. Shankhamala Roy and Professor Oritra Majumdar, joint conveners of the webinar, are to be thanked for their seamless execution of the webinar. Special thanks are due to Srimati Shreya Chatterjee and Sri Oritra Majumdar for the excellent technical support and their untiring efforts at making the webinar successful. I would also like to thank Srimati Jayanti Datto, IQAC Coordinator, Professor Dipankar Bhattacharya, Dr. Shamata Bishwash, and all the members of the webinar committee for their constant support and encouragement. Last but not the least, my heartfelt thanks to the innumerable members of the audience, including our dear students, without whose wholehearted participation the webinar could not have simply happened. With these few words, I would like to officially close the webinar and would like to hand over the microphone to Sri Oritra Majumdar for feedback and certification procedures. Thank you. Over to you, Oritra.
Thank you, Dr. Moshe Majumdar. Sorry, Moshe Bandyopadhyay. I'm just reading from the screen. My apologies. Thank you, Dr. Moshe Bandyopadhyay. I will now draw the attention of the participants to the certification process. I will be pasting a link in your chat box, and when you fill up that link, this is the feedback form. You fill up that link, and you will then receive certificates in your mail within 24 hours. Generally, the certification process is very fast, but in case there is any delay, we will try to reissue the certificates after 24 hours. So please don't immediately comment, or please don't immediately message us that we have not received it. Please wait for some time. Another thing is that some participants have tried to enter the meeting very late, towards the end or during the vote of thanks. We will not be able to allow them, because it's their policy that only those participants who have been there for a substantial amount of time will be allowed. So in case anyone finds that they have not been allowed, they can contact us directly and we'll clarify your stance or position. I'll also paste the feedback link in our live stream. So anyone who is participating to the live stream can also fill it up and submit the feedback, and they will receive the certificates. So I do not have much else to add at the moment. We have had a very enriching, very informative webinar. We have listened to two scholars, two activists who have shared their experiences and knowledge. And to all of this, I believe all the participants as well as the organizing committee themselves have been deeply enriched. On that note, I believe we can draw this webinar to a close. I thank Dr. Benjamin and Dr.
One second. Please allow Ruchira Goswami to leave. I mean, she has given a fantastic lecture. Really, it's the classroom experience for me, as if I'm attending a kind of MA class or MPhil class. What a fantastic experience I had. I never had the experience of listening to Ruchira for such a long time. It's fantastic experience. I'll go back to CRG and tell others what a wonderful speaker she is. Fantastic. Okay, we may leave Aritra. Both of
Thank
us
Yes,
can
you.
sir.
leave now. Okay.
Yes, sir. We are
Oh,
done, sir. Thank you,
thank you.
ma'am. Thank you, sir.
Thank you.
Thank
Thank
you.
Uh,
you. It was wonderful
Thank
to
you
be a
so much.
part. Thank you
Thank
for the
you so much.
fantastic questions. Thank you.
Thank
thank
you.
you. So the participants who have received the feedback link can fill up the uh, feedback form and they will receive the certificates shortly. Those who have filled it up can leave the webinar. They can leave the Google Meet. The
How can
organizer.
I quit? I do not find any place where I can leave my this. How to do it?
Sir, you click on the phone button in the middle, sir. The
Acha,
down phone.
acha.
Yes, sir. So, anyone who has filled up the feedback link can please exit the webinar. We are at the close of the webinar. The technical committee members, the organizing committee members will be here for a while longer in case there are issues, technical issues. And once we leave, we'll also stop the live stream immediately. So once we leave, once we are done, you can contact us directly on the emails given during the initial part of the webinar, and we will definitely try to solve all your queries, all your technical questions. And as we said, if anyone has not received their certificate, please wait 24 hours. Then we will reissue the certificates to anyone who has not received it. So please wait 24 hours before contacting us. So on that note, I'm closing the live stream. Shreyadi, are you there?
No, she has
Sejal?
left.